Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Happy Friday. Happy Friday, my friends. It's Freaky Friday. Fun day Friday. It's Monday Friday. How's everybody? Happy afternoon. Happy afternoon. Good afternoon. 7:46 a.m. where I am, and that means it's about 1:46 p.m. on the East Coast. And I get to sleep a little bit later today, so that was exciting. And then I was just watching my phone. I think I was up around 4:30. I was watching my phone to see what was happening, if anything was going to happen today. And the jury did have a question earlier today, but we did not get to hear the question. We, meaning not me, because I was not awake, I think, when it happened. But apparently the jury wanted to see the bottle of pills. And they also wanted to see the knife or the picture of the knife. Yeah, yesterday was rough. Yesterday was rough because the stream got interrupted like 6 times because I still don't know what it was, if it was a swatting incident or what, but apparently it happened to a lot of people that were streaming the Lindsay Clancy trial. And so the stream was interrupted, and this black card came up on the screen and said, stream has been removed for policy violations of YouTube. And then I waited it out, and then it just kept coming back. So it was, 6 times that we got interrupted. So we really didn't get to watch jury instructions, which we can do now while we're waiting if you want. We're going to be joined by a special guest around 2:30. Tom Kokonowski is going to join us. He's a defense attorney from Massachusetts. He's a fan favorite. You know him, you love him. He's got a cat named George Clooney, and he was the defense attorney in the Brian Camp trial. So he's going to be coming on at 2:30. And maybe we should look at jury instructions or listen to them, because we didn't listen to them. Sharon, who are you and why are you here? Old news? Okay, bye. Yeah, maybe George Clooney will make a special appearance. He's got a cat named George Clooney. And so we can do that. But first, we have something. Oh, look, I already put it on the bottom, replay of jury instructions, because I thought we should replay them because we didn't see them yesterday. And I think that manslaughter is an interesting sort of compromise option for the jury. Although I don't know how they would get there. They've been out for how long now? About 8 hours? 7 something? Oh, you got the tickets. Always get the tickets. Always buy the tickets. Always do the things. I had a special treat for you, though, first. If you joined me yesterday for the afternoon, or I guess it was evening stream on the East Coast, we watched a lot of baby AI videos. Well, she did it again. She did one for the Lindsay Clancy trial. We're going to watch that in a second. But check this out. This was on page 6 this morning. Looks like they're already planning or writing a movie or a miniseries or something about the case. And this broke this morning, 9:45 a.m. Hollywood gripped by Lindsay Clancy murder trial with the biggest studios plotting projects. Told you they were already writing it. As the verdict looms in the shocking Lindsay Clancy murder trial, Hollywood studios and streamers are among those glued to the case, and we hear that execs have been deeply obsessed. Sources tell Page 6 Hollywood that numerous studios and streamers are interested in bringing Clancy's story and trial to the screen. While no deals have been made, the grim case has dominated discussions in the hallways, conference rooms, and elevators of studios, agencies, networks, and production companies around town. We hear everyone, and I mean everyone, is talking about it, said one Hollywood veteran. They put a picture of Lindsay in there. Massachusetts jury continues deliberations today to decide the fate of the 36-year-old Clancy, who's accused of strangling her 3 young kids before trying to take her own life and jumping from a window, leaving her paralyzed. Clancy's defense team says the accused killer should not be found criminally guilty for the gruesome deaths because she was in the throes of severe postpartum psychosis and that she heard a man's voice telling her to carry out the brutal killings and attempted S. Oh, Bob said Netflix has been there every day. Yeah, they're doing, but Netflix usually does documentaries, right? This seems to me like it's like they're looking to do something scripted. Adding to the intrigue, the case has divided trial watchers. Multiple reports have said there's a wide swath of women who passionately believe Clancy is innocent. And here's a shot of the gallery with, look who's sitting in the front row. All the cops. I think that must be from yesterday, right? Because there's Bob Motta in the third row in the black shirt. And then all the cops showed up yesterday in the first 2 rows. Because I don't see him in this photo. Maybe this is him on the left. This is the one that I called Ian Ziering. He looks like Ian Ziering. He testified. In a piece titled, "Everyone Thinks Lindsay Clancy Killed Her Kids Except Women Online," the Free Press scribe Susie Weiss wrote, "The murder trial that's taking place now is to ascertain whether Clancy should spend the rest of her life in prison or in a mental institution. But on some deep and feminine corners of the internet, there's a chorus growing who believe that Clancy is innocent and allege that her husband Patrick is the one who committed the unspeakable crime. Additionally, then there is a wider concentric circle of women who believe that Clancy did the murders but want to stand in solidarity with her." Yeah, where were the police for John O'Keefe? Thank you, Mrs. Monty. Thank you. They can show up here, but they didn't show up for John O'Keefe. Wild. In parens, it says there's no evidence that Patrick was involved, and Clancy does not deny killing her kids. A Post-opinion piece recently said of Clancy's supporters, the women standing outside the courthouse have inexplicably assigned Patrick as the villain of the story, calling the scene outside the court a mass psychosis event. Isn't that ironic? The choice of the word psychosis. We hear that the case has been particularly hotly debated among female execs in Hollywood, splitting Gen Z staffers, millennials, and Gen Xers in their opinions over Clancy's guilt. There's a picture of these people who I believe were standing out for women's mental health and not particularly there to celebrate Lindsay Clancy, but you know how they like to spin things. Such intrigue has only fueled the concept that the case could be a blockbuster entertainment project. People are chasing it, said a source, adding that networks and streamers alike could be in the hunt, and top documentarians' names are being bandied about. There was even a rumor going around that Netflix had a staffer in the courtroom, which we hear is not true. All right, so it says it's not true. But it is very much in their wheelhouse, said a source familiar with the streamer, adding there would be no surprise if Netflix and every other streamer would be eyeing the case as a possible project. One entertainment exec says that no one will make a movie on the project till they know how the story ends. Dun, dun, dun. Stay tuned and start casting. Yeah, that's interesting. Dana says there's a reason millions of people are riveted to this case because we all see ourselves. Right. Or maybe someone we know and love that may have suffered. We got spammers in here already. Hold on a second. This was a last minute add-on, so I'm hoping the mods are just lurking in the background. Hold on. Oh, please. Okay. Okay. Today's going to be like whack-a-troll. It's going to be whack-a-troll. Whack-a-troll today. So we're going to hang out together until if and when. I don't think there's going to be a verdict today. I just don't. But we have things that we could talk about. And Tom Kokonowski is going to come on. And we're going to chat. Swifty Lou says, thank goodness you're back, Melanie. The law and crime chat live. Well, live chat was so nasty. I mean, told you so. Thank you for your 5. Mrs. Bouquet says, better give Mel some coffee money before YouTube goes rogue. Thanks, Mrs. Bouquet. It may have been the topic yesterday. It may have been the fact that so many people were streaming the same thing at the same time that YouTube bots flagged it all as copyright strikes. It could be that Patrick Clancy's lawyers are out here trying to shut everybody up. I don't really know. There's a lot of theories about what happened yesterday, but listen, whatever happens, happens. It's Aloha Friday. It's Mahalo Friday is what it is. Yes, somebody confirmed that Dr. Mac is no longer employed by that company. I saw that. Good afternoon, Kansas Granny. Thanks for being here for 9 months. Belle Evenham, thanks for becoming a member. Lauren says that she was in the courtroom for closings, and it was emotional, and the ADA was a faker. Dun, dun, dun. Arlene says, now to catch up. Not being on jury watch today, so the jury had questions. Yeah, the jury wanted to see the pill bottles and the knife or the picture of the knife. Oh, Team Brittany was gifted a membership. Look at that. Hold on a sec. Brett, you got a membership. Woo woo. No, the Matas actually got in touch with Law and Crime, and Law and Crime told them that they are not the ones who was striking anybody. And Law and Crime and Court TV are owned by the same company. So that's what I heard. That's what I heard. Listen, everybody, it depends on whoever's you're listening to is going to have their own version of what they observed in the courtroom. And so there were some reports that there were jurors like burst out into tears. And then some other people who were in the courtroom were like, well, I didn't see that. Did you see that? It depends on who you're listening to and who you're watching, I guess. So I don't know. Oh, please. I don't know. Kevin Reddington, I think, needs to be near the courthouse. I don't think he needs to be in the courthouse. I don't know if he's hanging out in his car, but he's being mobbed outside the courthouse by paparazzi like he's like he's a celebrity. And I don't really think he likes it. Yeah, Meditating Honey Badger with a $50 super chat says, I'm so glad to be back and watching live again. I've been dealing with a mental health related family crisis for 2 weeks. I'm so sorry. And trying to keep up on the trial best I could. The glimpse I got into the mental health system has been eye-opening. I think that this trial has been eye-opening for a lot of people in a lot of ways with regard to the mental health system and the way that things like this are handled and the way that meds just be thrown, maybe the meds are just thrown at people willy-nilly over the television without any sort of physical in-person examination or any in-person visits at all. And telemedicine wasn't a thing before 2020. Before the panty, everything was in person. And I feel like we've come to just accept a lot of things as the new normal that I don't think should be the new normal. That is one of them. I think that telehealth visits are a recipe for malpractice. It's my opinion. Some of it maybe can be done over telehealth, and maybe it's easier for everyone involved if they can't get there. But there's a lot of things that should be done in person, including, business, deal making, I've told you how I feel about this before, that, people who are in sales and who are in advertising and media, everything used to be done in person. Deals used to be made at the restaurant, the bar, the golf course, the sports game. Now everyone does everything via email. The new generation does everything by email, and they're like, oh, well, the guy never got back to me. It's like, okay, well, did you pick up the phone and actually call them and try and set up an in-person meeting? It's crazy. But anyway, thanks for coming to my TED Talk, and thank you so much for your $50 super chat. So our good friend, Karen Reed, trial.ai, because that's where she started. Hang on one second. Did a baby video. We watched some of the baby videos last night, and we needed the laughs, didn't we? We did. We needed the laughs, and it was a welcome diversion. And this is fantastic. So I want you to go follow her on all the socials. She has a YouTube channel. I'm going to put it up for you so that you could see it. Give me a minute. And her channel is called at KarenReedChild.ai. See there, it's in the corner. And this is the new Lindsay Clancy baby AI video. If you guys haven't seen it yet, I think it's hot off the press.
You active member in the Catholic Church?
Yes.
So you're aware that murder is considered a mortal sin?
Holy cow!
Or did she seem to understand the questions you were asking?
Yes.
And her responses, did you understand those?
Yes.
So what she was writing made sense given the situation. She wasn't writing, is there a unicorn in the corner, right?
What? I'm sorry, I didn't hear that. What?
If there was a unicorn in the corner.
Judge.
It's a yes or no.
You make it impossible to answer that question.
Next question. But the bottom line is that you didn't get any fingerprints.
Correct.
And that you could have just said that, right? Just come on the witness stand and say, we didn't get any fingerprints.
I saw her 3 years ago. I see about 200 patients a
I'm
month.
sure you're very busy, but this is a murder trial, doctor. Did you review your records?
Kelsey, do you have a copy maybe that she could look at?
Oh, I have a copy.
That might be easier for the witness.
Now, are you an active member in the Catholic Church?
Yes.
So you're
that's on loop.
aware that
It's on loop. I thought I was already subscribed. No, there's no verdict yet. We're on verdict watch, which means that if the verdict comes in today, we'll be here for it. So we're going to review some stuff. We're going to have Tom Kokonowski come in about half an hour or so. And he's a Massachusetts criminal defense lawyer. And he's great. Oh, looks like there's another one up that maybe she only has on TikTok. Hold on. Let me see if oh, please. All right. Here's the newest. I think this is new.
The district attorney and I.
Which one? Which one of these two?
Ms. Sprague.
Ms. Sprague. Okay, you spoke to Jen Sprague, and what did you say to her?
Sprague.
What is it?
Attorney Sprague.
You spoke to Jen Sprague, and what did she tell you? Who told you that you couldn't talk to the mother?
Ms. Sprague.
Attorney Sprague, please.
Right. Attorney Sprague. Crushing pills is really a challenge. It's just kind of a laborious process.
Where did you get that from?
I believe Patrick told me that.
So how do we know that that's even drugs or medications or whatever word you want to use?
It was Patrick Clancy's observation.
And how did you learn that she had crushed the pills?
I learned after interviewing her husband, Patrick.
And did you read a transcript or listen to a tape, or how do you know that?
There was evidence of powder. Patrick told me about.
Do you know that, or are you just agreeing with me?
I'm agreeing with you.
Okay.
The Commonwealth has now rested their rebuttal case, and then the jury will begin deliberating.
I mean, if you were not able to come to your screen for this, because it's only a minute and a half long, and we need some laughs. And the way that one of them is adjusting the bow on the other. Let's just watch this one more time, okay? Here you go, KarenRetrial.ai. We got to see this one more time because many of you may not have been at your screen and you may have thought this was just the real court footage, but no, it's not. KarenRetrial.ai on all the socials makes these videos, and we watched some last night again from the Karen Retrial. There is a baby AI version of me, and I love her so much. Here we go. Let's listen to it again.
The district attorney and I.
Which one? Which one of these two?
Which one of these two? Which one of these two? One of my favorite moments, maybe my favorite Kevin Reddington moment of the trial.
Sprague.
Ms. Sprague. Okay, you spoke to Jen Sprague, and what did you say to her?
Sprague.
What is it?
Attorney Sprague.
You spoke to Jen Sprague.
The hand on hip. The hand on hip is everything to me because she does. And I mentioned that yesterday when she was doing her closing. She had her hand on her hip, and I'm like, I just don't like the look of that.
And I.
Which one? Which one of these two?
Ms. Sprague.
Ms. Sprague. Okay, you spoke to Jen Sprague, and what did you say to her?
Sprague.
What is it?
Attorney Sprague.
You spoke to Jen Sprague, and what did she tell you? Who told you that you couldn't talk to the mother?
Ms. Sprague.
Attorney Sprague, please.
Right. Attorney Sprague. Crushing pills is really a challenge. It's just kind of a laborious process.
Where did you get that from?
I believe Patrick told me that.
So how do we know that that's even drugs or medications or whatever word you want to use?
His eyes bulging out of his head.
It was Patrick Clancy's observation.
Yeah, I mean, it's wild to me that they keep talking about these crushed up pills in this glass of lemonade when it was never tested. And Lindsay said they didn't even have lemonade in the house. Or no, Patrick said they didn't have lemonade in the house. And Lindsay said that there was a tumbler next that she crushed, like she might have false memories. We learned about false memories in psychosis. They didn't test it. Crushing pills is a laborious process. Some of those benzos just melt onto your tongue. Like, I don't know how laborious that could be. They never tested it. Patrick said they didn't have lemonade in the house, right? It was Patrick said they didn't have lemonade, and Lindsay said it was lemonade, and where's the cup? And why did nobody test the cup? Why did nobody open the drawer?
And how did you learn that she had crushed the pills?
I learned after interviewing her husband, Patrick.
And did you read a transcript or listen to a tape, or how do you know that?
There was evidence of powder. Patrick told me about.
Do you know that, or are you just agreeing with me?
I'm agreeing with you.
Okay.
The pregnant pauses for that guy were everything. The pregnant pauses. Do you agree? Do you agree with me, or you just wait? Do you believe it? Wait, look at these stuff. This is a great screenshot right here. Oh my God, it's everything. But we know that only one wears the bow. So many people. Tell me if you're one of these people. Didn't have been listening to the trial, maybe not physically watching it, but listening to it while they're doing other things, as many do. Didn't even know that there were two different ADAs, thought it was the same woman the entire time. If you're one of those people and you just realized or figured out at some point during the trial that it was really two different women, put a 1 in the chat. That's hilarious to me. But not really, because they're very similar. Their voices are very similar. Yes, there's one. Me, they sound exactly the same. Call Me Ken says, I thought it was one person. Many of you thought it was one person. Oh my gosh, look how many ones are in the chat. So many. That's wild. You thought it was the same person. Wild.
Patrick told me about.
Do you know that, or are you just agreeing with me?
I'm agreeing with you.
Okay.
The Commonwealth has now rested their rebuttal case, and then
Tapping his fingers on the desk. Baby Reddington tapping his fingers on the desk.
I'm agreeing with you.
Okay.
Wait, I'm sorry. I got to hear that again.
Patrick told me about.
Do you know that, or are you just agreeing with me?
I'm agreeing with you.
Yeah, he just agreed with him. I don't really know that for sure. I'm just agreeing with him. Oh, the betting markets aren't giving very good odds to the Commonwealth, says David. I asked about that the other day. Like, what are the poly markets saying? Like, can you bet on the outcome of this trial? That's wild. Did you place a bet? What are the odds? What's the payout on that? He said, I'm just agreeing with you. I'm just agreeing with you. I don't really know that. I'm just agreeing with you. Like, he was beaten down by the end of his testimony, and everyone thought he was such a great witness for the Commonwealth.
Okay.
The Commonwealth has now rested their rebuttal case, and then the jury will begin deliberating.
I mean, come on. All the props to KarenReedTrial.ai. These baby videos give me life. They just do. They just do. Lindsay B says, was Sprague allowed to argue that Lindsay asking for a lawyer while handcuffed in the hospital showed she knew what she did was wrong? Typically, evidence that someone asks for a lawyer is not allowed in because there's nothing wrong with asking for a lawyer. In fact, you should never talk to the police without a lawyer, especially if you're innocent. But you know who's a great person for that question is going to be Tom Kokonowski. I'm going to save that for him because he's coming on soon. Chastity gifted 5 memberships because she's amazing. Lindsay P, thank you so much for your 5. And Tora Laura says the way they bent over backwards to avoid saying postpartum, 7 months since delivery. There's a word for that. It's postpartum. That's right. That's right. DC for life says, hey, Cupcakes, first time posting and love your channel, Mel. Oh, welcome, welcome, welcome. The first row was panned at the beginning, all the cops, etc. And I think this is why Shred pointed directly at them with the job well done snark. Yes, yes, I think you're right. I think you're right. Peachy Tree's been here for 8 months. Love you too. First to see the sun, New Zealand says, in New Zealand, it affects roughly 10 to 20% of new mothers, as well as about 10% of non-birthing partners or fathers. Right. Apparently fathers can suffer some sort of postpartum stress also, even though they don't have the hormones to affect them. But there is, some, they used to call it the baby blues, right? That can be attributed, I guess, to fathers as well. Welcome to all the new Cupcakes. Friend of Dog gifted 10 memberships. There's a lot of new Cupcakes. Welcome. There's special emojis at the bottom of your screen. You just got to click on that little smiley face button. And it's some of my favorite things, Grateful Dead, Dancing Bear, and Steely. And there's also a Dave Matthews Fire Dancer in there. And then we have so many emojis that we repurposed from the Karen Reed trial and others. We are outraged. We have lies, lies, lies. Yeah, by the Thompson twins, a couple of Twilight Zone emojis. There's a nope emoji. There's a sigh emoji because Judge Cannoni uses sigh into the microphone so loudly. Smooth as butter for Alan Jackson. I said that you guys could use that for Shred. And the Solo Cup, the puffy jacket. Oh my gosh, Boss Baby. We watched Lally the other day. He was acting like a boss baby. And he had a binky. He needed a binky. And there's How Dare You and Tiny Jesus and Cardi B and all the fun things that we have come to know and love throughout my coverage of all of the different trials that we have watched together. Thank you, Friend of Dog. You are so super generous. Sarah Fitz in Dublin said, hi, Mel. Could Lindsay be found not guilty by reason of insanity, if not, quote, psychotic? I mean, so depressed she wanted to commit S and take her kids with her rather than leave them without her. No commanding voice, just profoundly depressed. Yes, if whatever mental disease or defect she was suffering from, and now listen, all of the experts agreed that she was suffering from a mental disease or defect, right? So it doesn't really matter what that mental disease or defect is. You don't even need a diagnosis to claim a mental disease or defect. What matters is whether, as a result of whatever that thing is, it doesn't have to be a psychotic break, she was unable to appreciate that her actions were criminal, or she was unable to prevent herself from doing it. So it doesn't specifically have to be any particular diagnosis or just, or event. But yes, they could find that. It doesn't have to be psychosis. It doesn't have to be postpartum depression. It doesn't have to be postpartum psychosis. Meditating Honey Badger says trying to get help for a family member in crisis is a speed task. Yeah, it's hard. It's hard. And it was even harder like around 2020, 2021, 2022. The wait for a mental health provider was like you couldn't get an appointment for 6 months, right? If you know, you know. Nana Bear, after his closing, Kevin Reed sat down with his hands flat on his desk. Lindsay reached out and squeezed his hand. He loves her. He really loves her. He says that. Swifty Lou says, will you be covering another trial after this one? You become a pivotal part of my workday, Mel. Well, I usually go live pretty much every day anyway to talk about whatever it is we talk about. So I can keep you company during your work days for sure. The Shanna Gardner trial that I was going to cover has just been pushed to 2027 because of some really crazy developments. Her husband, Mario Fernandez Saldana, was found guilty, and then he was just brought up on new charges involving SA of somebody under the age of 12. I haven't had a chance to delve into it yet, but because of that, her trial's been pushed to 2027. I don't know. Do we have a new date on Sarah Grace Patrick yet? That was supposed to happen. Will I cover Alan Jackson's new trial? I don't think there's going to be cameras in the courtroom for Fraser Bohm. But if there is, I would. No, I think Shanna doesn't have bail, right? She's being held. I don't think she's not out on bail. Shanna Gardner, for those of you who don't know, she's the heiress to the Stampin' Up family out of Utah. And it is alleged that she and her husband hired a guy named Henry Tenen to take the life of her former husband, Jared Bridegan. And apparently this guy put a tire in the road so Jared would have to stop and get out and move the tire. And that's when he gunned him down. And I think his 2-year-old child was in the backseat. It was a horrible story. Horrible story. So don't worry, Swifty Lou. I'm here all the time anyway. If there's anything else happening, any more trials starting in the next couple of weeks, let me know if there's something that you want to do. Will you be having a serious discussion about the trial soon? I don't know what that question means. What does that question mean? What do you mean, will I have a serious discussion about the trial soon? Tom Kokonowski's coming on. You look like a rage baiter to me, is what you look like, since today's the first day you've ever commented on this channel ever. And I don't fall for that. Oh, no, the ADAs are not that cute, Melanie. You're adorable. Oh, thank you, Ms. Kelly. Thank you so much. Pokeroo says, I heard the jury asked to see the knife and the bag of pill bottles. Yes. Not sure if true, but I also heard the request was denied. Yes. What could this request mean? Let's wait for Tom Kokonowski. Could mean a lot of things. It could be construed either way. Could be good for the prosecution. Could be good for the defense. They could be arguing back there how many pills were missing from each bottle. Or what did those pill bottles say? If it was the bag of pill bottles that were in the drawer that were never seized by the police, that they didn't even find, because they didn't even open the drawer, they could be like, how did they not find these? What was in there? Could these be the things that she crushed up? And did they want to see the physical knife or the photo of the knife? I thought there was a lot of stuff that went back with them into the jury room. Typically, that's how they do it in Massachusetts. So, and I know they've got the video. They've got the video of one of her forensic interviews with one of the Commonwealth experts. And that video has got to be, I don't know, 4, 5, 6 hours long. And if it was me sitting on that jury, I would want to watch that video because I would want to see Lindsay Clancy talking to somebody, anybody. They haven't really heard from her at all. They've heard a lot about the things that she said allegedly to people, but it is a way to get her testimony in without her having to get on the stand. And so if it was me, I would want to see her demeanor, her cadence, her speech patterns. I would want to hear the things that she said to these experts. so that I could evaluate her credibility. So I think that they absolutely should watch that video. And I think that if they do, it's going to take a couple hours. And so I don't think they would come back today. And her body language, everything, her affect. Here for Humanity says, I'm behind, but the word is that Dr. Mack has been fired. Yeah, I heard that too. Or he left. I don't know if he's fired or if he left. Thank you, Mean Girls ADA, for your super sticker. Thanks, Lynn from Canada, for your super chat. Says, thank you, Melanie, for all your expertise and guidance during these past weeks on the mods. New member, thank you for tuning in from Canada. Aunt Lydia's Bow says, am I back? I think you're back. Been here for 12 months and you're back. Aunt Lydia's Bow. It's such a great username. Pebs says, this was the first Massachusetts judge I really liked. Thank you for your 10. There are many that I like. The judge who tried the Dr. Ingolf Turk case, the Harry Turk case that Kevin Reddington was his attorney for that as well. Remember that judge? We called him Stanley Tucci because he looked like Stanley Tucci. I think his name is Halal, Judge Mark Halal. Like him. I like Judge Doolin. I like Judge Frenier. I think there are a lot of really great judges in Massachusetts. Unfortunately, I think it's the bad judges that have been trying all the cases. Mass Dad, you're here. Haven't seen you in a while. Unless you've just been buried in the chat. Yeah, Diane Frenier, Mark Halal. I think there's a lot of good Massachusetts judges. I just don't think that, I think some of the trials we've covered have just been the ones that we didn't really like, but I thought Sullivan was great. Is it too late to get the babies into evidence? Says there's always a coffer. Oh, you're so funny. I love how you take the things that I say, my quips, and you make them into your usernames. That's because you're so creative. Caitlin Ann says, I truly don't know how I did life without you. That's a lot of pressure for me, Caitlin Ann, but I'll take it. I'll allow it. Thank you. Starflower says, we were taught in nursing school that postpartum is 12 months. It takes 12 months for a woman to heal mentally, emotionally, and physically. I mean, that makes a lot of sense to me, especially if you're breastfeeding, right? And with all the hormones that are involved in breastfeeding and then all the hormones that are involved when you stop breastfeeding. And it's bizarre that the United States of America and the DSM treats it so much differently than the World Health Organization. And there are other parts of the world that are so much more advanced in their care for postpartum moms than our country is. It's wild. Thank you, Angel, the Aussie who's been on replay and just wants to say thank you. You know, all you guys are saying that was Dr. Mack fired. I don't know if he's fired or if he just left. I have no idea. I don't have access to their HR. I know it's floating around there on the internet that he's no longer on the website. But CT Insider reported Dr. Mack is no longer employed by Children's Health System, says Christy Reed. Oh, you mean by the hospital that he worked for? I thought you meant like by the forensic company, by the Park Dietz company. And so I don't know. Amanda, thanks for your super sticker. Welcome, Missouri Mama 5. Nicolette Hall says, will you cover the Charlie Kirk trial? I don't think so. You know who's doing a really great job with that, and I would highly recommend that you watch because she's really dug deeply into it, is Andrea Burkhart. She's a really real life friend of mine. She's a law tuber. She's been doing a great job on Charlie Kirk, and I would highly recommend that you go watch her for that coverage. Guess who's here? Are you ready? Give me a thumbs up if you're ready back there. Showing up early. Okay, let's see. Hold on, here he is. You know him, you love him. He's there for you. He goes everywhere in Massachusetts. If you need a criminal defense attorney, he'll go anywhere. He's like the traveling Tom Kokonowski. Here he is, my friend and yours. Tom Kokonowski. Hi, Tom.
My camera's working. Is my microphone working?
Look at you and your new equipment and your new lighting. And you got the memo on the baseball hat. What does yours say?
Mine is the prep school that I went to, football, Williston football.
You're so she.
I postgraduate 1 year because I couldn't get it done in 4 in high school. And but it was the most pivotal year of my life. Anyway.
I know, you've told me about that. And then you went to Trinity and so did I. And we were there at the same time for freshman year. And we lived in the same dorm room. We didn't ever know each other.
Which one was it, Jones?
Better late than never. Yes.
So I'm also, if you don't mind, going to use you for technical purposes. This is my microphone. Am I too close? Am I too far? Because I'm watching I watch myself on my recordings and I'm like, oh my God.
Yeah, Tom's got a new channel. What's the name of your channel, Tom?
I changed it again. It's The Court Steps with Tom Kokonowski.
All right, so everyone go follow him on The Court Steps with Tom Kokonowski. Well, the only thing here is that I'm taller than you, so I feel taller than you. I should move back.
How about this?
And I have a crappy webcam because I'm traveling, so you look much crisper than I do, but I like it. Take your glasses and just tilt the arms of them. No. I'll show you how to get rid of the glare. I'm here to help. It's so funny because so many people were sending me like emails like, I don't know if you know this, but Tom Kokonowski has a YouTube channel now. And I'm like, yeah, I've been helping him. There you go. If you tilt the arms up, it feels weird. Yeah, just like that. And then there you go. No glare. See?
Okay. You invited me on to make fun of me.
You love it.
But that's okay. You're where?
You
somewhere
love it.
Somewhere not around
I'm
here.
in Hawaii. It is 6 hours. 6 hours behind East Coast time. But yeah, you look awesome, Tom. The ladies love you. How many we'll talk about that later. People are really thirsty over you. I don't know. And it's just so weird because it's like,
oh my goodness. It's hot enough in here. I don't need to sweat anymore. You're making me sweat.
Why do they feel like that's okay to do to a man?
I'm
right?
very,
like
very,
the
very.
Men don't do it to me. I just think it's like weird. But whatever.
I appreciate all fans. Or whatever, fans or not, fans or haters or whatever.
Viewers. All right, let's. We got some questions already here. So you were awake, obviously before I was, because you're on East Coast time. And so this morning the jury had a question. What do you know about that?
I knew that I was about to try to take a nap, and I saw that they had a question, and so I waited. And I didn't know if it was the stream that was editing things, but all I heard was the judge wanted to see everybody at sidebar, and they went sidebar, and then that was that. Unless I missed something, sounds like they resolved whatever the question was at sidebar, assuming so that they didn't want it on the public record. But my understanding is that did they grab some of the bottles, the prescription bottles? There's something about the question about prescription medication.
That they asked to see the knife and the bag of pill bottles. And also the request was denied. What do you think that request means?
Oh, it was denied? Yeah, I don't know. I made the mistake of listening to people. I think I switched to Court TV. People were talking about the prosecutors looking happier than, come on, please. I think to me, it became pretty clear that maybe that side of the room recognized somewhere along the line that they were having a problem with the way that they were sort of appearing, and that they kind of changed the way. I noticed a change in the way that they spoke and carried themselves, which especially during the closing. But I also thought the closing was the best part of their case. So I don't know what those tea leaves are. If the judge said no, if they grabbed, and again, I'm going on, did they grab the bottles and bring them over? And that's why people knew it was about. So maybe did they want those bottles back there?
I think so, but typically, well, tell us how it works in Massachusetts. Does the jury get to bring all the evidence with them back into the deliberation room?
Well, I remember, and I've gotten a lot of the information on this case from, as you were talking about, I go everywhere in the Commonwealth. I had a couple of trips out to Western Mass, which is a 3-hour drive one way. So I've been listening to a lot of this, not being able to watch a lot of it because, of course, I am a law-abiding citizen and I would never do anything that would jeopardize anything. So after I peeked at the phone maybe for a second, my understanding was that there's some things that were still marked for, I don't know that everything is an exhibit. I just remember it being late and Reddington using something that was not an exhibit but was marked for identification at that point. So I don't know. I don't know if they're in evidence or not. Because didn't he find them?
Yes.
Didn't they find them?
Yes.
So
He
I
and
don't
Patrick found them. Like he went with Patrick to the house. Like, I don't know how many days later. You guys probably know. I don't know if he said 11 days later, but he did say all the bottles were empty. And then he said that the police never, like, he even asked for them. He said you can have them, you can test them, and they never took them from him. And so I think, yeah, just to explain to the audience the difference between something that's marked for identification. So sometimes things that they talk about in court during the trial are marked for identification, but they never are admitted into evidence for various reasons. Like there's some sort of reason why things would not be entered into evidence, like no chain of custody, things like that. But they have to mark them for the record, so that they are part of the record on appeal or just the trial record in general. And so some things are marked, but they're not entered into evidence. And so you may be right. Maybe that bag of pill bottles was never entered. It was just marked because he wanted to keep waving it around, which I thought really helped with his argument of a lousy police investigation.
There's a drawer. He brought the drawer, and it's not a funny case, but Reddington is really something.
He's fun to watch, isn't he?
Yeah, and he is, but I literally 75% of this case I listened to as I was driving because I had 3 drives out there. So 3 times 6. I was in the car that many hours listening to, of course, on your channel when they weren't taking you off every 5 minutes. Now I know what it must have looked like when I tried to come on to your show without Ethernet.
No, I mean, you live, you learn.
But it was for the first time, it was very informative to me. An old dog learning new tricks every day. Just listening instead of watching. Everybody, the judge, the clerk, everybody. So I wasn't able to see what Reddington was doing a lot of times, but I found it really informative and really instructive for me. A number of ways that just the way he changes tone, the way he changes attitude, the way he is snarky, the way he becomes super snarky. Like when he grabbed on, I mean, he could not have drawn it up better when he called the prosecutor Miss Prosecutor, and she said attorney prosecutor, and the judge yelled at Reddington, it's attorney prosecutor, and he said, okay, attorney prosecutor, and then the doctor called her Miss, and he was like, no, it's attorney.
He goes, attorney Sprague, please.
Yeah, so he's I don't know that I do know. I know that I would not be able to be that quick with something like that, nor would I have the whats, I don't think, which is one of the really interesting things. And I've heard people talking about Reddington and the judge. Some people saying, do they know each other? It seems like they're buddies. And I just see, because, I'm not too far behind Mr. Reddington, but I mean, you got a judge who I've never been in front of with, shock of gray hair. He's been at it for a while. You got Reddington as the sometimes grumpy old man, sometimes funny old man, shock of gray hair, losing his hair. And the way that they interact with one another is not necessarily friends, but they've probably battled each other for the last 30 years.
Yeah.
That's what it strikes me as.
Reddington's been trying cases for a long time. He's 75. He rides a Harley. He's got a bunch of tattoos with like Latin sayings, and he just seems like a cool guy, and he just seems really compassionate. And another thing that I loved about his style is the way that he could. I just went out of my head, that thought. The way he plays dumb sometimes, like to get the witness to explain things like an expert. He's like, well, what does that mean? I don't know what that means. Tell me about that. Right? Technology.
Nope. No question. No, that guy for any age to be able to keep everything in line, organized inside that 75-year-old brain, and to be able to question with the information, explain the information, cross-examine with the information. I mean, just sort of like some of it is sometimes, shucks, old guy.
Like
this isn't in that.
television.
Wait, this isn't in evidence. Can we just, it's great. I sometimes am that way. The thing that I am going to steal from him, which I know that I don't do, and I'll bet you he doesn't even know that he does it anymore, is, and this is what I learned, this is what I recognized mostly as I was driving one day back when he was, I forget who he was beating the you-know-what out of on the witness stand. But as you know, and for those who don't in the audience, when you cross-examine when it's your witness, it's basically got to be open-ended questions: who, what, when, where, why. Even though a lot of this trial, for appropriate purposes, he was we don't need to do all of this stuff. Let's just get to this stuff. So however you want to get it in, prosecutors, you can ask however. Otherwise, you object to leading questions or whatever. But a leading question is, you answer the question. You don't ask it. You answer the question, and then somehow find a way to put a question mark on the end of that answer. And I recognize that he changes up the way that he puts the question mark on the end of each of those questions, something to the effect of, that hat that you're wearing, Attorney Little, it's beige in color, right?
Yep.
That hat you're wearing, that's beige. That's beige in color. Am I right? Correct? Am I correct? Am I wrong? Just the way that and I'm like, do I do that? I don't think I change it up as much as he does, but I'm going to try to start doing that, because in my ear it was I don't even know what it was, but it was effective in my opinion, the way that he was doing it. So thank you, Attorney Reddington, for I'm straight up stealing it for my next trial.
And that's what all good trial lawyers do, is we learn from other trial lawyers, because they don't teach you that in law school. The only way you learn is by watching other great trial lawyers try cases. And I think that kids who are in law school now have such an advantage, because they have a wealth of information and knowledge that they can just watch on YouTube to see how the masters do it, to learn from them and borrow things from them. And what you're saying is even more obvious, because every question by the ADA was fair to say, blah, 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 fair to say, blah, fair to say. I mean, everyone gets sick of it.
Correct.
Adam Lally, what if any, what if any, what if any? They ask the same damn questions all the time. I found the ADAs in this case to be leading throughout the entire trial, asking questions that gave the answer in the question, so the witness would know how to answer, even if it was objected to and sustained. They could then ask it a different way, and then the witness would know how the answer that they wanted based on the first question that was asked.
I agree, but I one of the first times I started watching this on your show, it was either you, well, it had to have been you. Or no,
okay.
You were.
It's all right. If you cheated on me, who did you watch it with?
No. Either you or one of your viewers who was chatting in the live chat was talking. Somebody said, "I wish he would stop leading the witness," and so I, paid attention to that, and they were, but that's what I'm talking about. There was a huge chunk of this trial where Reddington was like, "However you got to get it in, we're not even contesting it. Go ahead and ask leading questions, because that's not what we're contesting, and we don't need to go through all of the gore and all that kind of stuff to try to inflame the jury." So yeah, there was a lot of that, but that's what it was. Somebody was complaining that he wasn't objecting to it. That's what it was. He wasn't objecting to it because it didn't matter.
Right. I agree. Somebody said that the jury has another question. So
Excellent.
I have the feed up right here. So we'll put
Okay.
it up. And I've got a different feed today. So we don't want to miss a thing. Hold on. This is live, right? Yeah, this is live. WJAR. First full day of deliberations. Hold on.
Be interesting to see if they do it only at sidebar again.
Yeah, typically, I mean, the cases that I've watched in Massachusetts, and tell me about the cases that you've tried, but typically, don't they read the questions out loud? Like,
Yeah,
in front of the gallery, at least. I mean, not in front of the jury, and then they talk about it.
the
They did that in
procedure
Go ahead, sorry.
that I have always been involved in my hundreds of trials is if they have a question, the lawyers are called in, the judge comes out with the question, knows he or she's on the record saying, okay, blah, 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 jury has a question, I have it in my hand, and I'm going to read the question for the record, and they read from the handwritten question into the record and then ask the lawyers, how do you want me to deal with this?
Right.
And then sometimes there's fights, sometimes there's not, oftentimes there's an agreement. But yeah, that's normally how it goes. That's what I was expecting on the first one. But
if those were the questions that they wanted to look at the pills and the knife, does that give you any hint about what they're thinking?
no, because as I heard it mostly, Reddington, part of Reddington's defense is that there's just this sort of, pill mill that was her treatment, just drugs from behind a screen and all these drugs. And she was, she was taking them like she was supposed to take them. And on the other side, I believe I had heard in the closing argument, the prosecutor was saying she wasn't taking them the way that she was supposed to be taking them. She was doctor shopping and all that kind of stuff. So, although I don't know specifically what Reddington used that drawer of pills for. So,
and there was another bag of pills. There was another bag of pills that Patrick had in his car. He said that he was going to be like returning them or something. Do you remember what that was? What his excuse was for having the pills in his car?
I didn't see that part.
Yeah, did you watch Patrick's testimony at all? A lot of people have a lot of feelings about Patrick, but I'm not going to fall into that.
I was able to catch
getting sued.
I was able to catch like 10 minutes of the end of the actual, and then I watched some of the replays, but I don't think I was able to put it together cohesively enough.
I'm sure the chat can tell us what his excuse was for that.
I have no doubt they can.
Yeah.
As I am learning on my own.
Nothing gets by them.
I know.
All right. So I don't know if they have a question. We'll see. We'll see if they come back with a question. Where did you guys hear this from? Because let's see what the chat is saying over here.
Who said they have a question?
Somebody in the chat said they have a question. Maybe they saw it on the internet somewhere.
If they come out with something like, can you redefine reasonable doubt, stuff like that, they're close.
Yeah. We'll see. But we'll see if we even get to see it.
True.
Where did you guys hear that there was a question? Because they're not saying this on this channel. Let me see if Law and Crime says anything about it.
Just for anybody keeping score, Liam is the first cat into the Kokonowski studio.
All right. Is he going to make an appearance?
I wish he would, because he is such a love, and he is a 24-pound tabby. And
wow,
he is just a love.
All right, hang on a second. I don't know why their camera's not up. They must be on a little bit of a delay. They said the jurors were dressed casually today. Do you buy into that? That when they're going to come back with a verdict, that they dress up?
Well, my understanding that what I saw was that they were dressed a little bit better than they have been.
Oh, really? See,
that's what
everyone's
I
got a
heard.
different opinion. It's like, what do you think is fancy? What do you think is casual?
Yeah,
You
somebody
know?
said they're coming in t-shirts and stuff, and that today I guess somebody had a polo on that didn't have a polo on before or whatever. But no, I don't. Camp's jury. Well, Camp's jury was only out for 4 hours, so.
Oh, that's right.
As I was walking up and down Main Street, and you were talking to him.
Some other people say that they heard that they were dressed up. Some other people said I heard they were casual. So I don't know. I guess it depends on who you're talking to. People say nicer. You're dressed nicer today.
I don't even look at them when they come in.
Yeah, well, if you're trying the case, but if you're an observer, would you be looking at them?
Well, of course. Well, yeah. Especially if there's like boots on the ground and looking for content while there's nothing going on right now.
Drago's Pet Mouse. The jury breakdown is like 9 women, 3 men.
Yep.
As I understand it.
That's what I heard.
And the alternates were picked. It was a little bit weird. It was a little bit weird because she was shaking them in like a cardboard box. Usually, when I've seen it before in Massachusetts, they have like a bingo drum and they roll them around and they have balls. She had like a cardboard box and folded up index cards. It looked like
the bingo card roller. The bingo roller is cards, no balls.
Oh, it's cards.
Yep.
I thought in Karen Reed trial too, they had like big, or maybe it was different. Maybe it was Turk. Yeah. So the jury composition is 9 women and 3 men. And what do you think? I think it could go either way. Sometimes I think women are harder on other women. What do you think?
Yeah,
having tried so many cases in Massachusetts, are you keeping count of how many trials you've had in Massachusetts? Well, you've only practiced in Massachusetts, right?
Yeah. Well, I I can't believe the number when I am conservative about it, but I had 30 jury trials under my belt as a student prosecutor because I knew that's what I wanted to do. And I have very easily, very conservatively, if I have done 2 trials per month for 31 years.
Wow.
Yeah.
Do the math on that.
Yep.
It's a lot of trials.
Yep. Yeah, I didn't even realize it until, well, I didn't realize it until I started doing this stuff, and I'm looking at my face every day going, holy crap, I got old. And then doing that math because people are asking me that question. I don't know. It seems crazy, but I probably have done more than 2 a month, but we're going with 2 a month. And I've done 5 bench trials.
Oh, do you think this would have been better as a bench trial? What are your thoughts on that? And explain to the viewers how you make that determination of bench trial or jury trial. I'm just looking for something. I'm not ignoring you.
I mean, I could see the reasons for considering a bench trial. I have no question that Attorney Reddington and Ms. Clancy talked about it because, you know, the sad fact is there are 3 children who are dead and that they are admittedly dead at their mother's hands. So the question becomes, is there going to be a jury of 12 normal, quote unquote, people who are going to be able to sort of put that aside other than for, you know, what the actual facts of the case are, to be able to be fair and impartial? That's, you know, that's like having just a simple drunk driving case. You know, one of the questions that's always asked is, that I always ask is of jurors individually, sub up this.
Thank you, Team Brittany. Team Brittany put your link in the chat and says, sub up to this old man who does 2 trials a month.
Quick before he dies.
Oh, stop. You can't jinx yourself like that. Don't do that.
Forgot what I was saying. Well, I'm sure it was about me.
About a bench trial, a jury trial. Shout out to Paul's Barbershop in Quincy, by the way. Tom, if you need a haircut, Missy, our girl Missy, might hook you up and do.
How did you know I need a haircut? I actually canceled one a couple days ago. I'm lucky that my guy left his barbershop. He's a lobster fisherman, and but he still cuts hair. So I get to go to his beautiful house and hang out at his house with he and his kids and his girlfriend and stuff, and get my hair cut.
Oh, that's nice. So you can't cheat once you find a good person. There's no question. Somebody lied to me. They lied to me. There's no question.
Right. Oh, okay.
False alert. Oh, yeah. So wait, we were talking about women being harder on other women. Apparently the 4 person is a grandma.
Honestly, my gut reaction is I would rather have this decision in the hands of women than men. Based on life experience, being a mama's boy myself, as once proclaimed by a therapist who was helping me out, and being a guy. I think that she is in better hands with 9 women than she would be with 9 men.
I think so too. What was your breakdown in the Brian Camp trial, and do you think that had any effect on the acquittal?
I can't remember, but I think it was. I think it was nearly split. It's pretty close to 6 and 6. I forget. It wasn't exactly 6 and 6, but it was close. All I know is, and I forget if I've said this on your show before, the most important question I asked all of those jurors, especially the women, is have you ever been in a fist fight? Because if you've not, you have no idea how exhausting it is to throw punches and be hit. And, as you know, the facts of Brian Camp, where he was fighting for his life for 20 minutes.
Naked, buck naked.
Buck naked. Yeah, I did my last video. I did the transcript that I had taken rather than play the 911. And Brooke wound up saying that once she reported the first shot, the dispatcher said, "What's Brian doing?" She said, "Putting on clothes." She says he's been naked this whole time because we went to bed.
Yeah, that was a wild case. If you guys didn't watch the Brian Camp trial, check it out. I have a playlist down below. Here's an interesting question. What did you think about this? Did you listened to the closings, right?
Yes.
Did you think it was improper for Sprague to argue that Lindsay asking for a lawyer while handcuffed in the hospital showed she knew that she did was wrong?
Yes.
It was proper or
No.
improper? Oh.
No, I don't. And I think I actually had maybe texted you that I expected him to make objections, because here we don't. I mean, as you know, it really has to be bad to object during somebody's closing, like actually during the closing argument. It is sort of sacrosanct. You just don't do that. Like, this is where each person gets to do their thing.
Yeah.
And so in order to preserve the record, at least here in Massachusetts, we let them do what they do. And then at sidebar, you make your objections for the record. There were a couple of things that I had expected that maybe he would object to. And I don't even know, did they go sidebar right after closings?
I don't remember.
Because if they didn't, then there probably were no objections. But
I mean,
yeah,
he's been preserving the record all along.
Oh, he's hyper preserving. I mean, he's been preserving the record for like what, 50 years or something.
Right.
Yeah. If there's anybody who knows how to preserve the record, it is he. That is for sure.
Somebody says she asked about a lawyer. Oh, no, we know that Lindsay asked about a lawyer because the hospital lawyers came in when she was changing her healthcare proxy. Yeah, but also you wake up coming out of a coma and you see that you're surrounded by, cops guarding your room, and they're all in your room and you're handcuffed to the bed. You might want to be like, do I have a lawyer? Like, and there's nothing wrong with that.
Absolutely.
Tell the viewers that nobody should talk to the police without a lawyer, right? Especially
Nope.
if you're innocent.
Yeah, I actually was on the phone with a potential new client today, and he was shocked that I said don't talk to him when they call back. And he was like, "What? What?" I'm like, "They're not your friends. They're calling you for a reason. They're pretending to be your friends because here's what happens at the time that they're questioning you. Either they don't have probable cause, and you talking to them is going to give it to them, or they have probable cause, but they don't have beyond a reasonable doubt. And you talking to them down the road gives them beyond a reasonable doubt. So go ahead and talk to them if you want, but I suggest that you don't."
Another one of Reddington's tactics that I love is when he does things like he says to the witness, "So when you called the mother," and then the witness is forced to say, "Oh, I didn't call the mother." And he knows he didn't call the mother, and he's got to correct him. Oh, you didn't call the mother. That would be something that I would steal too. I love that. I love that so much. And he's done it. He did it a couple of different times.
Yep.
And I thought it was so effective
Yep.
because it really makes the witness look stupid because of course you should have called the mother. Like if you're going to speak to collaterals in this case, why would you only speak to Patrick?
Correct. And right. And so when he asks it that way, my interpretation of that is obviously knowing that they didn't call the mother. It makes it you're making the argument to the jury right there that this person should have been called and they didn't do it. And this witness is now contributing to your mini closing during the witness.
Yeah.
Yeah.
And
that's
so
brilliant.
That pivots us into the mortal sin. You're a Catholic, practicing Catholic, aren't you, Mrs. Clancy? So you know that murder is a mortal sin, don't you? He did object. At first I thought he didn't object because I didn't hear it. I couldn't hear it. But when I went back and listened to it in my earbuds,
Yeah.
he objected at the same time. The judge was like, "Let me see you over here."
Yes, I saw that. I was actually watching that one.
And then they did it again. A second time. But this time they were not talking about murder being a mortal sin. This time it was about taking your own life being a mortal sin and how you wouldn't go to heaven anyway because that's a mortal sin. And then he did move for a mistrial, but a lot of people were upset he didn't move for a mistrial the first time, but he did move for a mistrial the second time, so that protects the record. Because is it true that in Massachusetts, if you don't object to something during the trial, you waive that issue on appeal?
Yeah, unless it's such an important issue that the appellate court is going to take it up anyway. But yeah, you need to, the general rule is if you don't make the objection, and you learn as a newer lawyer, you learn by reading those cases of ineffective assistance of counsel where the Supreme Judicial Court says, this case should be overturned because this lawyer did not object when they should have. And so this client did not get a fair trial because of his or her own lawyer for not making the objection that it's crazy. It's not crazy. It's appropriate.
So tell us why you think that was improper.
Well, number one, my understanding, and again, correct me if I'm wrong, somebody, if not the foreperson, is wearing a crucifix.
Oh.
I don't know if that's true or not, number one.
Yeah, I don't know.
Number two, that's not, you don't bring religion into this. And this,
Isn't it like ethics 101? Like you
can't
bring up religion to bolster a witness's credibility or to impeach a witness's credibility. It's just not done.
Yeah. It's I actually was expecting him to, that was a perfect place for him to do a little theater with an objection on the first one. And I didn't see the second one. But yeah, the judge did the theater on the first one, if I'm not mistaken. I want to see counsel up here.
The second one was
The fact she did it twice is amazing.
Yeah. Was it the same lawyer that did it both times? I don't recall.
I have
But
no
the
idea.
second one was during the witness, during an expert witness. She did it. Do you think a mistrial should have been granted? Do you think it was egregious enough that it prevented a fair trial? Because I
That's a
thought on that myself.
that's a yeah. I mean, twice, once, maybe not. And then, you know, I've had a couple of times where it's near the end of the case and it feels like it's going well. And you sort of make the judgment call, hoping you're not in the mass case books. Your name is not in the mass case books as not
Right.
having objected or asked for a mistrial. But
Right.
yeah, there's been a couple of times where I've not, where I probably could have, because I think we're winning and we don't. Okay, so then say you get a mistrial, probably not gonna, but say you get a mistrial. Now you're at a different judge, different jury. The prosecution has seen your case. They know what your defenses are, and they're going to be ready for you next time. It's like, yeah, I'm going to take the shot at this one and not ask for a mistrial because I really don't want one.
Not to mention the added expense, hiring all the experts again.
Oh God, yeah.
You're hourly. You know, he's not a public defender. He's getting paid by the hour,
Well, I mean, Karen Reed's was a mistrial for a different reason,
right?
and
I'm
she's
very-
selling houses and signing, you know, Netflix and hoping for a civil verdict. I mean,
Yeah.
it's very, it's expensive.
Very expensive. Although
Yeah.
there is case law, Oregon versus Kennedy, that says that if a prosecutor goads a defense attorney, that's the language, goads a defense attorney into requesting a mistrial and it's granted due to prosecutorial misconduct, that it can be granted with prejudice, which would have been, but that's a risk that you take. You know, you don't know that that's going to happen.
Right. Yeah. If it's something that's very clear, although twice invoking Jesus as a prosecution witness, seems, I mean, Jesus was a prosecution witness in this case.
Right. There's somebody who looked up the statistics on this, maybe 36 to 40% Catholic in Plymouth County.
Easily.
If, as you said, somebody was wearing a cross or a crucifix, and there's one juror who was thinking, well, she's probably not guilty by reason of insanity. But wait, if I find her not guilty for taking the lives of her children, doesn't that make me a bad Catholic? And so if a juror starts to think that way, now you've injected this whole thing into the trial that never should have been there.
Right.
And I think they did it intentionally. I don't think there was any mistake about it, especially because it was done twice. And I just think it's egregious. And I find the way that they have tried this case to be gross. What do you think?
That was bad. In my opinion, that was, I mean, the first time, maybe, probably not, but maybe accidental, but it's not. There's no way it's accidental. But let's just say the first one we let slip.
Well, the first one, she asked the question. The second one, the witness sort of volunteered it.
Oh, the witness did. That's why I didn't see that
the
one.
Witness volunteered it. He said, I was talking to Lindsay and she told me that she wanted her kids to be in heaven with her. So that's why she took their lives, because she was going to take her own, because she thought they'd be better off with her. And then he kept going. This guy kept rambling. He was doing a narrative testimony. He said, but then I said to her, I said, well, you're Catholic, right? And so you know that if you take your own life, you're not going to heaven anyway, right? Because it's a mortal sin. And he used the exact same terminology, mortal sin.
I'm sorry. Now that you're saying that, I did see that, and I was flabbergasted.
Yeah.
And that was not a mistake.
It's almost like she prepped him to say that. I mean, how do you can't prove it, but it's gross. I mean, if there was ever a motion for sanctions, like later, they could move for sanctions, right? And then if they had an evidentiary hearing and they got the witness on the stand, you could ask them, like, were you prepped about mortal sin? That would be interesting.
Well,
certainly. Would ever get there?
If there's a conviction.
Yeah.
Sure. That's going to be visited for sure if there's a conviction.
Yes, I think it was Kirk. I think it was Dr. Kirk, Captain Kirk, that did that. What do you think about all the cops showing up yesterday and sitting in the first two rows? Where were those cops when John O'Keefe's murder trial happened?
I didn't see that.
Yeah, so the first two rows were all cops. Many of them testified in the trial. And of course, District Attorney, what's his name? Tim Cruz showed up. He was there too. Could that be considered like intimidation of the jury? I don't know. It was certainly intimidating when Brian Albert and Colin Albert came into court and stared the jury down during Karen Reed's closings.
Yeah, I mean, I can understand where that comes from, but I mean, they've been living with this case too for how long, and getting in my opinion, the bejesus kicked out of them around the courtroom for, in my opinion, most of the trial. So I could see them wanting to be there. Yeah.
Did you see the objection when she started talking about Andrea Yates in her closing? And do you think that that was proper?
I did not see that.
Skeptical Allie says, people say we will learn from this trial. Why didn't we learn after Andrea Yates? 2 postpartum mothers in Tennessee have taken their kids' lives this summer. I think this trial has historical implications for a lot of things, a lot of public awareness. What do you think?
It's one of the things that I was thinking as I create content myself is just the antiseptic nature of certainly this trial and the way that psychiatry is practiced for someone in Ms. Clancy's situation. You have a guy, this would not be as exposed now worldwide without Reddington. This doesn't happen like this without somebody like Reddington.
Right.
Proctor doesn't get exposed without somebody like Jackson.
Rosemary Scapiccio. She's had a big hand in getting Proctor exposed, getting his whole phone extraction. She happens to also be handling the medical malpractice case for Lindsay Clancy. I didn't realize that she does both, civil and criminal.
Yeah, I had heard that. Was she there today?
Today, I don't know if she's there. You mean for closings?
I heard
yesterday. Yesterday, she was in Norfolk Superior doing a hearing with Adam Lally on the stand, so she couldn't be there yesterday.
I watched some of that repeat today on Vinny. Vinny Politan was.
Oh, did Vinny do it?
Yeah. He's got a whole. Have you seen his studio lately? It looks like Darth Vader with a seat.
It's very, very video gamer, right?
Yes.
It's like Vinny after dark. He's like like a video
blood
game
red, blood red with black borders and a Starship Enterprise captain's chair and maybe a cape. I don't know.
Was he wearing a leather jacket? Busy wants to know if having Commonwealth police in the front row could be considered jury intimidation.
No.
Good answer. Okay. Great question. 45 says, thank you so much. If found not criminally responsible, would she be considered a felon?
No.
Oh, that's interesting. Where would she go? What is the mental hospital for women in Massachusetts? Because we know Bridgewater is only men, or that's what my viewers have told me.
Yeah, that's a good question. I don't know. Bridgewater is the only, and Tewksbury to a certain degree, but I don't know where she would go.
And if she's convicted, if she's found guilty, and she's sentenced to prison, would they have the ability to care for her needs in a prison while she's paralyzed from the sternum down, needs help with the activities of daily living, going to the bathroom, everything? Would they have the proper care? No, Bridgewater State is only for men. Worcester, somebody's saying Worcester or Worcester. How do you say Worcester?
I say Worcester.
Okay, Worcester.
I come from nobody from here to Worcester. People from Cape Cod and Boston think that the Commonwealth of Massachusetts ends at Worcester. And then there's New York State. They don't know that Western Mass exists. They don't know where it is. they don't care to visit it. So we also don't talk like, and I don't think I'm getting an accent out here yet, but we'll see.
I don't think you have an accent at
No.
all. Back to the question of how would they care for her daily needs? Not sure. Do they have that?
They do. Obviously not. I don't think it would be as, robust as it would be on the outside. I'm sure that they have a particular place for people with severe physical disabilities. I just don't. I wouldn't want a sister or a mother to have to be treated in a place like that with those injuries.
No. Some people think that people who think that she should, be convicted to prison and live there forever, think that, going to being confined to or sentenced to live out however long in a mental hospital is some sort of cakewalk. And right. Explain.
I mean, it's kind of like prison without being prison. I've never been in them, but I think of a Clockwork Orange kind of situation.
Yeah. Many people who have or have worked in the prison system, many of whom are in the chat, say that it's like 10 times worse. Like the conditions in the state mental hospital are 10 times worse than prison. Like horrible, horrifying.
Yeah, I've had I've had some clients who've spent time in both places, lots of time in both places, and if they had a choice each time, they prefer prison.
Cat Lady said that she thought that I had Rob Lowe on for a second until she saw your name. I think that's a great compliment.
Rob Kokonowski.
Kokonowski.
Thank you.
All right. A lot of here. Jen Devine says she just subscribed to your channel. She's expecting great things. No pressure. Thanks, Jen, for your 10.
Well, I have a motion to suppress that I won that I plan on going over for any nerds who want to look at laws, and specifically as I push back a little bit against my very good friend, a case where everybody's rights not only lived, but the entire case was dismissed as a result of, the issue is the legal system versus the system. And that's another thing I was thinking about. The systems in this case that failed everybody are clear. This case meaning Clancy. The systems that failed everybody in Reed are clear. The systems on a smaller degree, because we were stuck in between the two Reed trials, that failed everybody in the Bryan Camp matter, where the communications between state police and local police, and so I'm wondering, and I'm expecting, to be honest, the systems failed Reed and Camp. I know I love this debate, which is why I'm bringing it up. I love I love people that leave comments that they don't agree with me. I love it. The systems that failed Brian, the systems that failed Karen Reed, the system, the legal system, in my opinion, did its job. And the reason that the legal system did its job in those cases was because of good lawyering, certainly on the defense side. On Reed, I was all right, I guess, in the Bryan Camp. But you
were great in the Bryan Camp case. We cried. How many of you watched? If you watched the Bryan Camp trial with me on this channel, just put a 2 in the chat, because we had 1s for something else. Put a 2 in the chat. So many people. We adopted him as our collective adopted son, and we cried when he was acquitted.
But I think I told you, I don't know if you knew that I had them come out here with their camper. I didn't even know he had a camper. So the whole family came out. I got a campsite for them right down the street from me. And it's the first time since I've seen them all together since that trial. And when the little girls came out, I'm doing it now. I'm going to freaking cry right now. When the little girls came bounding down, not as little anymore, but when they came sort of shooting out of that camper with their little razor scooters or whatever it is that they fly around on, and had no idea who I was. That was the greatest time of two people not knowing who I am, because that means they know very little of all the details. They have no idea who I was. And so Brian had to introduce me to them again, which was great.
And you kept their father from prison, which is so huge.
And
right?
he kept their father from being killed and their mother from potentially being killed and them from being hurt. So he's the hero, not me.
That was a horrible prosecution. I mean, like, for those of you who don't know, it involved a home invader that busted into the house in the middle of the night. Brian Camp was sleeping. He was naked with his girlfriend. They weren't married at the time. 2 little girls sleeping in the next room. And he tried to kill Brian Camp. And luckily, Brooke was able to run out of the house, right, with the cell phone to call 911. You've been playing the 911 tapes on your channel. It took them something like 20-something minutes to get there. They wrestled. Brian got downstairs somehow and got a hold of like a rickety musket, as Kathy used to call it, got off a shot, and then went outside, right? And then, tell me when I'm wrong, the 911 operator told Brooke to tell him to go back in and check on the home invader's condition. And then he got up to try and attack Brian again, and Brian shot him again. And the DA said, well, the first shot was okay, but we're going to indict you on the second shot because that was just like, you went too far. The kill shot.
About sums it up. Yep.
What county was that again? Hampshire?
Hampshire.
Insane prosecution. And what was he charged with?
Manslaughter. They presented murder. And so, you know, the legal system, and I know that everyone who comments disagrees with me on him. The legal system not working for Brian says because he was charged, because he was indicted, it failed him. And I get it. I don't think he should have been either. But, you know, when a grand jury is asked to choose, they said no to murder. And,
right.
And, you know, probable cause is a very low threshold. So, and, you know, he and I joke that the longest time that he spent in jail was the 6 minutes that it took when I walked him in, because I negotiated with the prosecutor a $10,000 bail. We will walk in, don't arrest him. And so Mom had the cash. We walked in to court. There's a picture of one of my favorite pictures. They're putting him in handcuffs, and you can see my back. And as soon as the handcuffs were on, Mom ran down to the clerk's office with the cash, posted it, and they went back in and got Brian uncuffed and then brought him out. So that was the most time that he spent. And he didn't face a murder charge. He faced manslaughter, though. You know, I don't know what a judge would have sentenced him to.
Thank God you got him off. Manslaughter carries up to 20 years, right? Up to 20 years in the judge's discretion.
Up to 20 years, yeah. There's no minimum mandatory or anything like that.
And so it's interesting that manslaughter is on the table for Lindsay Clancy.
I was going to ask you guys, do we know, did either side ask for that, or was it just the judge that said, I believe that there's enough for manslaughter, I'm going to instruct on manslaughter?
Reddington asked for it.
Good.
In the initial charge conference, and then fought for it again, and the Commonwealth didn't want it in there, but
of course not.
Yeah, but he got it in the end, which would be, I mean, maybe a compromise verdict if the jury can't agree on murder 1 or murder 2. Also, there's 3 verdict sheets, 1 for each child. I don't know if anybody knows that, but that's it. There's 1 verdict sheet for each child, and not guilty is an option on each of them. A lot of people didn't think not guilty was going to be an option at all, and I'm like, how could it not be? Do you think they could come to different verdicts for different children?
Yes. If I understood some of the testimony, and please correct me if I'm wrong, I forget, it was during one of the it was during one of the expert witnesses' testimony. I'll try to be as gentle as I can. What I heard was the voice that was talked about was heard, and then something happened to one of the kids, and then there was no voice anymore before the other two. Is that right? Because that's what I was thinking. If that's true, yes, there could be different verdicts.
I don't know if the voice was constant throughout. You guys let me know. I thought she heard the voice, but she only heard it that one time, and then she never heard it again. But I think the voice was constant throughout, what was
the event.
Happening.
Yeah.
But she hasn't testified. That's
right.
why I think it's so important, because the jury, what did get into evidence was one of the forensic interviews that was on videotape. One of Lindsay's interviews that she gave to one of the guys the experts that just saw her in 2026. And they were, Reddington fought to have a camera in there during the interviews, which great move, because usually for independent medical exams, like as an attorney, I would always go with my client to an IME, or I would send an attorney to go with them. But if you can have the experts' interrogation, as it were, taped, I mean, that's great. And if I was on the jury, I would want to listen to that, because it's the only time they're ever going to hear Lindsay speak.
Right.
And if that video is like 4 to 6 hours long, that's why I think this is going to be a longer deliberation, because I think they should watch that video.
Yeah, I don't think they're coming back today.
I don't think so either. One of the people said the voice was constant until after she was airlifted to the Brigham and came out of the coma, and then she never heard it again, right?
Okay, so it was after the whole event.
Yeah, and she says in her lawsuit, in the civil lawsuit, which didn't come into the trial, obviously, but she said she had been hearing the voice all day long until finally she couldn't resist the commands anymore, and that's when she broke and did the acts. So, but I'm just thinking maybe because Callan did initially survive, that there could be less intent, for him. You never know what a jury's gonna hang their hat on in that room. You never know that some jurors could be thinking like, this is a really important thing, and other jurors can be like, who cares? Some jurors could be hanging on the experts, and other jurors could be like, they canceled each other out. I don't believe anything any of the experts says,
Yeah. On a obviously extremely different level, in my opinion, the manslaughter, because I was jumping up and down for the second Karen Reed trial, that they need to ask for a standalone OUI so that they can have, if somebody's looking for something, have the OUI. Here you go. And sure enough, I think, hedging my bet, it's either going to be not guilty by reason of insanity or manslaughter. I think that you want the manslaughter in there. If they're looking for a compromise from first degree.
I just don't see how you get to no intent. I feel like she either had intent or she was not criminally responsible. I don't know how you can get to she just did it negligently, recklessly, knowing that it could cause death, but it didn't really. I don't know how they would in their, I can't rectify that in my brain, so I don't know how they would.
I'm a little surprised manslaughter's in there, but it's good.
Yeah, tell me tell the viewers what the elements of manslaughter are in Massachusetts.
Well, essentially that probably the best example that I actually remember from law school, which is fascinating. It's a reckless standard. So I've got to make sure I'm careful with the example that I use. Well, the example that they use in law school for recklessness is basically you do something reckless that causes the death of somebody else. It doesn't have to be intentional. It doesn't have to be with premeditation and malice aforethought. So the example that they used in law school that I use is you have a gun and there's a crowd of people, hundreds of people standing in front of you. You don't know any of them. You don't know anybody from Adam. You just decide to shoot the gun into the crowd and someone dies. You either knew or should have known that that act was likely to cause serious bodily injury and the death of somebody. So,
yeah, or it could be driving 100 miles an hour on the highway, weaving in and out of traffic, going the wrong way. Like you're not intending to kill anybody,
right.
But what you're doing is so reckless that you knew or should have known that it could kill somebody, and that's why you can be convicted of manslaughter. But so I don't know how they could come to manslaughter, but it's good that it's in there if you're a defense attorney.
Yeah, I wish did they do the charge? Yeah, I didn't watch the charge conference. Did they do it in open, the charge conference? I should have watched it.
They did the charge conference, but I didn't get a chance because my stream kept getting yeeted yesterday. I didn't get a chance to watch the actual jury instructions that the judge gave to the jury.
Yeah, I would have. There was one cross-examination that I am. Actually, it was a direct examination. Reddington, I'm going to get the recording of how he questioned his own expert, because I haven't done a lot of psychological expert witnesses. I've done a lot of experts, but not that type. And just the way that he did it is just concise, clear, simple.
You mean you're going to order the transcript or order the recording, or you can just get the transcript off YouTube? I'll teach you how to do that later. You can print the transcript from YouTube. Hogan Sally said, I loved Resnick, but I would like to see more women experts. Can we verify Matt got fired or resigned? I have no idea. And also Margaret Spinelli was supposed to testify for the defense, but I don't know if she had a medical issue or something, and she couldn't, apparently.
So Rob Lowe in A Few Good Men, is that what we're talking? Or
Rob Lowe in what else was Rob Lowe
He's
in?
Great. Dirty Dan, not
So
the, what was
good.
he in? He was
Part
in,
of the
was
Brat, he was part of the Brat Pack. He was in
wasn't his big breakout the dance movie? What was that?
I don't think Rob Lowe was a dancer, was he?
Kenny Loggins, wasn't he? Didn't he do a dance?
No, that
movie?
was Kevin Bacon. That was I know what you're
Oh,
talking about.
that's
That was
right.
Kevin Bacon.
That's right. That was Kevin Bacon.
I love Rob Lowe.
He's great.
He's a sober guy too. He's been sober for like decades, and he speaks out about it a lot. He was in St. Elmo's Fire. He was in back in the day. This is going back to like when we were in
He's old.
high school.
Is he older than us? Me? Sorry.
I don't know. He might be like a year. He's like within 5 years, I would say. I think he's older because he was part of the whole Brat Pack with Demi Moore and like Emilio Estevez and like all those people. The Outsiders. I think that's where he really got his start. Oh, there was a movie called Class, 1983, Oxford Blues, 1984, San Elmo's Fire, 1985. About Last Night. Remember About Last Night?
No.
That was a great movie that he did with Demi Moore,
maybe.
I think.
Maybe I did. I don't know.
It's like
when was that? 84, 85?
Yeah, one of the original rom-coms. Jim Belushi was in that. Masquerade, that was another one. That was good. I don't think he was in A Few Good Men. Was he? I don't know.
Now I'm looking.
I'm sure the chat will tell us.
You also have to tell me how you put up Chaka in the corner, because I am putting up the Wizard of Oz behind the curtain, because that's what I feel like. That's what I feel like as I'm learning how to use StreamYard.
You upload it into the logo section of the. I'll show you. We'll have a tutorial. We'll do a tutorial.
Pay no attention. Pay no attention to Kokonowski.
Lokanowski. Yeah, we talked about this earlier. Our thoughts on them asking for the pills and the knife. Could mean anything. Could mean anything. Any further thoughts since we've had a chance to? Thank you, Chronically Curious, for your 5.
Well, the knife goes to the suicide attempt, right?
Yep.
I'm not supposed to say that word, am I?
Yeah, you can just say S for now, but
My bad. Shut my tube down, YouTube. Melanie got beat up.
A Few Good Men is coming to Broadway, actually. I can't wait to go see it.
Is it really?
Yeah, it's premiering in like October. Because I just looked it up. My daughter and I were looking to go to a show before she goes back to college, and I just saw that it's coming. I'm like, oh, it's here. And it's not. But To Kill a Mockingbird is. I saw it in London. It was amazing. Amazing.
How was my character? I'm assuming Horace Gilmer was in it. The prosecutor.
Yes. He was good. Probably not as good as you would have been, though.
Did they use the original script, like the terrible word that is used, or did they not use that word?
It's actually been rewritten by Aaron Sorkin.
Right.
Adapted by Aaron Sorkin for the stage, and they did use it. Yeah. Once or twice. Not as many times as I think they did in the book. Thank you, big boy, for your 5. A lot of people think this was a crappy investigation. Thank you on top. A couple of new members here. Welcome. And Mrs. Sarian. Only believe Mel. Oh, that's a great username. I love that so much. And then you super chat me just to make me say your username, and I love it so much. Yeah, Rob Lowe, after The Outsiders, had his first leading role in Young Blood. Young Blood. Oh, also, he was in a few, what the hell is the name of that sitcom? One of the funniest shows on television ever was not A Few Good Men. It's the other one. He was on The West Wing, which is also Aaron Sorkin.
That's right. He was on The West Wing.
The one where he lives with his brother and they live on Malibu and the beach. Why is it? No, that was Charlie Sheen. Forget it. I'm confusing him with Charlie Sheen. Never mind. He was in Parks and Rec. That is something I haven't watched, but my kids are watching it on loop. They're watching like every season of it. Maria Spaghetti, thanks for your empathy and understanding. Mental health is a gray area. In Australia, I was told I had PPD at 18 months when I stopped breastfeeding. Yeah, very common, according to the medical experts who didn't testify in this trial, that could be a sudden onset after breastfeeding because of hormones. Joey Perry says, new trial suggesting that Caleb Flynn from American Idol starts September 17th. We did cover some pretrial on him. It's interesting. We'll see if it really goes ahead. I was going to cover Shanna Gardner, but that just got pushed. Mom, 25 Boys says hi from Westfield.
She's from Westfield?
Yeah, she says, hi, Tom, from Westfield, Mass.
Go Bombers.
Elizabeth wants to know, she says she's worried about the autopsy photos that the jury showed, that the jury was shown. Should they have been allowed?
The answer to that question is to the extent that it is necessary for them to see that for the cause of death, but frequently there's a fight over how many and what types should be shown, because at some point it just becomes an obvious attempt to inflame the jury's passions rather than show them the medical part of things. So yeah, they're necessary, but to an extent.
Do they ever offer jurors counseling after really gruesome trials like this, where they're really, because there were people visibly sobbing during the 911 call, I think even jurors, and during the showing of these photos. Do they offer counseling for jurors?
I don't think so, and I think you are the newest lawyer to make some changes in the Commonwealth of Massachusetts, because that is a great idea.
Somebody had mentioned in the chat once that they actually do. Maybe it wasn't Massachusetts, but maybe it was in some other state where they actually do offer some sort of, because that's you can't unsee that stuff, Yeah,
even in mine, the photos were pretty bad, and so.
Oh yeah.
But prosecutor and I agreed on what goes in and what doesn't. He didn't play that game.
Piney Woods, who is also a lawyer, says, I think they asked about the pill bottles because they are exploring the Commonwealth argument about her not really taking the meds. I think they're doing their jobs. It could be.
Yeah, asking for anything, they're doing their jobs.
Mystic Rose Petals, truly hope the 9 women on the jury have had children, preferably multiple. I just can't see a prison having the capacity to care for such serious medical needs, can a judge overrule or determine that a state hospital is necessary? If she's found guilty, he doesn't have the.
So that's a really good question. And it's different than the one that I frequently face. When there is a charge that somebody is convicted of or pleads guilty to that has a minimum mandatory state prison component, I will always ask if it's somebody who doesn't want to go to state prison. Again, there are many people who, let's just say, have some experience in what I do, who prefer to go to state prison than jail. But there are also clearly some people who don't want to go to prison and shouldn't go to prison. So frequently I will ask for the judge to recommend a house of correction transfer, and the Board of Prisons doesn't care. They don't. You're probably.
What's the difference for people who don't know the difference
Between house of correction and prison?
Yeah. One's like the local pokey, like the Norfolk County pokey, and one's like
prison.
Why would a defendant want to go to one over the other?
Because, well, let's just say if he's been there enough times for a large enough number of years, he is familiar with the people. He's got his people inside. He knows how things run. He's got, or she's got, protection set up and waiting. They know how it all runs. And you're sort of running with the same type of people. It's kind of like the difference. This may be a very bad analogy. Actually, it would be a simile, right? If I use the word like, it would be like the difference between varsity and junior varsity, sort of in a negative way. House of correction is for misdemeanors. And a misdemeanor in Massachusetts is anything that's punishable by 2.5 years to the house of correction or less. And a felony is anything that's punishable by anything more than 2.5 years to the house of correction.
Yeah, so maybe they already have their gang set up in prison because they've already been there before.
Prison has murderers or Mers. Mm-hmm. Prison has Mers and Sers and Rers and real heavy duty people. And jail, although jail is not somewhere anybody would like to be, it's much different than prison. Having visited clients in both, even for me, it's much, much different.
How's the toy drive for the Camp family going? Beth wants to know.
That is a good question. I have not looked at it recently.
All right. Do either of you have thoughts on why the judge didn't stop Andrea Yates' comment immediately? I think it's because one of the experts brought up Andrea Yates, right?
Yeah.
It took Brett objecting for him to react. Also, Tom, when will we see part 3 on Brian Camp? Thank you.
Didn't I do part 3?
I can barely keep up with my own content.
I did the I don't know what I'm doing video. And then I did the I know a little bit more of what I'm doing video with the 911. And then I did a second 911. Yeah, I did number 3. Number 3 is up, but I used the transcript that I created rather than the 911 call. And I make the argument for
part 3 is up.
Systems versus the system.
Cheryl says, I noticed the woman with the cross. I'm thinking he used the coins because Judas stole coins, manipulating the truth with money. She stole the coins, manipulating the jury. I'll bet he was waiting for her to steal the coins. Well, that's interesting. Did you see when he put the coins down? Like anybody played pool? What are your thoughts on that?
I didn't like it.
How did you interpret it?
Well, my understanding was that as he was putting it down, he was saying, not like I dare you to, but he was like, I remember the first time he slammed it down and everybody was like, what the, and he's talking, I could tell he's talking directly to the prosecutor. I'm like, oh my God, this guy is crazy.
Right.
This guy is crazy. And when I recognized that it was a quarter, because they were quarters, right? He put a quarter down, and it was something to the effect of, go ahead and try to tell them that this is what it is. And then the second one was the same thing. Go ahead, he was, I don't know, he's paying her to pay you to do it. I don't know. But didn't she use those props in her own closing too? Didn't she
picked them up?
Didn't she take them off the table? Is it in one fell swoop or individually?
He put them down individually. I think she took them. I don't know. I was so distracted by getting like taken off. He said when he put the coins down something about playing pool, right? Because you know, if you want to get the next game, if you want to play the winner, and you're in a bar at a pool table, you put your money on the side of the rail, and that's how you get the next game. And I don't know. Johnny said he said first quarter, second quarter while placing the quarter. I challenge you to tell this jury is what he was saying.
That's what it was.
It down. And then I think she picked them up when she said, oh, well, I can, like when she was like refuting his points, I guess. They were challenge coins. Yeah.
Yeah. That's a long way of me saying I don't know. Because I have played a lot of pool in a lot of bar rooms. And
so
that's like I got the next game.
Right.
You put your quarters down and say you got next game.
Somebody said he was calling the shots, 8-ball and corner pocket. She put one in her pocket and then another one and then the last two. I thought there was only 3 altogether. She addressed each topic and took the quarters back. I mean, that's good trial lawyering when you can pivot from whatever your closing was to be able to then take those props and use them in your closing. That's a good skill to have. So many trial lawyers are so script oriented that even when they're questioning witnesses and they get some real gold from a witness, they can't like run with that. They just follow their script. You know, Lally was like that.
Right.
So that was excellent lawyering, I thought, on her part. But as far as the rest of the closing went, I thought her closing was so disingenuous. Even just like her tone was a shift from the way she tried this case that it was almost offensive, I found, because she had been trying to show that this was a fake attempt to take her own life from the beginning, that she was she was a drug seeker, and, you know, all these things. And then in the end, she's like, well, you know, she really did try and do it. And, you know, everything she did was so understandable. And I mean, it's so wild. The court's not over for the day, as far as I know. They're going to come into court to release the jury, right? They got to get back on the record to send them home, yeah?
Correct.
So, yeah, I have the feed up on my other screen here, and I don't see them coming back
Has he been cutting them loose at 4 or 4:30?
It's been 4. Yesterday it was 4, right? Or maybe a little after 4. How did you like the way he brought up Jack Nicholson in The Shining in his closing? I love that so much. All work and no play makes Jack a dull boy. Yep. I could just picture Jack Nicholson in my head. Like, he's back. What does he say when he like opens it? He's back, or I'm back, or whatever.
Yeah, when he's scaring Shelley Duvall in the in the closet. Here's Johnny.
So good, because that is like one of the most in film examples of psychosis. The way that, you know, Jack Nicholson's character disintegrates. Cameras have yet to come back. All right, so we'll just put them up so you guys don't think that we forgot about it. They're here. And we'll see if they're going to. Media is heading into the courtroom. I don't know. Usually they have to do it on the record.
Who's heading into the courtroom?
It says the media is heading back into the courtroom. I've got it up. We're not going to miss it. Everyone smash the like button while you're here. It really helps the algorithm. The jury did not have another question earlier. Thank you, protocol.
One of the very I'm sorry. I love watching Reddington handle the media outside.
I know.
They have no idea how to handle him.
And I feel like he really doesn't like all the attention. That's the vibe I get from him.
And
I
the
mean,
wheeze.
you would probably love it. You would eat it up if the paparazzi were surrounding you and like following you into court. You wouldn't need a bodyguard or anything.
I'm going to find out who Rob Lowe's agent is now.
I can find that out for you. I have IMDb Pro.
Yes,
Law 2's Most Hated Mob says, Tom, and he's amazing. He's 25 years retired NYPD. Tom, in my opinion, the detectives were told that Lindsay wasn't going to make it. The investigation was shoddy, but not corrupt. No excuse, just my professional opinion.
I agree.
Scott's got all the
Yeah,
keys.
I think come upon this scene, this situation, might have a tendency to say, yeah, this is easy. This is solved for sure.
LC McJD says, is there a possibility of judgment notwithstanding the verdict in Massachusetts if guilty? If so, any guesses on likelihood if they found murder one?
Yes, there is such a thing, but that's not happening in this case.
Yeah. I know of a case. Do you know the case of Sean Sousa? It's a case out of Fall River. He's a cop, and he was convicted by a jury and sentenced. He was actually convicted and sentenced. He was a cop from, I think, Fall River. I can't remember what police department. And his conviction was for the grape of his something like 6 to 8 year old stepdaughter, and also for the essay of another family friend under the age of 15, another girl. He was convicted by a jury and sentenced, and then the judge overturned the verdict and like quietly let him out in the middle of the night, like right before Christmas. And the DA of Bristol County has appealed it. I don't know if they've ever filed their briefs. I've been following that for a long time, but
it's that recent.
Yeah,
I did not hear about that.
I think his name's Sean Shawn Sousa, Souza. I've been stalking well, not really, because I haven't looked lately, but I was waiting for the appellate briefs to drop because it's so unusual for that to happen. And it was something like in the appeal, and I think Reddington represented him too, if I recall correctly, right? Jury going home per Kathy Russin. I don't know why they're not putting the cameras back on over here. Hold on, we're looking on another channel. Well, it is get to the Cape Fridays, Got to get to the Cape on Fridays.
It is nicely thinning out, however.
Is it really?
Yeah.
Why? Because it's getting close to the end of the season?
Yep.
For those of you who don't know, Tom lives on the Cape.
One of the greatest.
You're right. You talk about it all the time.
One of the greatest parties is coming up on Labor Day. The Beachcomber closing party is a blast.
Oh yeah.
Yeah,
have a ticket?
It's on my favorite beach. Don't need a ticket. I mean, if you get in, you get in. But it's my favorite beach in the world, including the Caribbean.
Really?
Yep.
Well, I mean, we really do have some of the best beaches in the world on the East Coast. I mean, the beaches here, well, not here. Well, I'm in Hawaii, but the beaches here are pretty amazing. But Long Island beaches too have some of the best. Like our ocean beaches on Long Island are sandy and the really nice like texture of the sand. And there's like a really long, like the distance from the beach to the water is like hella long. Like they're not short beaches, they're longer beaches. He lives down the Cape. That's right. He lives down the Cape. He says it's the best beaches ever. Yeah, we heard the jury's going home, but my thoughts are they've got to do it on the record. So
yeah, he's got to ask him the questions.
Right.
Or tell him. I'm sorry. Give him the admonishments. Especially now, ladies and gentlemen, we are here, and to ruin it by putting something on Facebook or reading something on Facebook or talking to somebody about it, and now we have to have a mistrial. Please don't. Please.
Yeah, don't do that. Don't do it. Don't talk about it. Samantha says, people in a distraught state do not crush pills into a drink. They neck the bottles down. So do you think that the eyes should be on Patrick Clancy? No, I don't. And I'm not going to perpetuate that here because his lawyers are coming after everybody, from what I hear.
Yeah, not even close.
I mean, don't you think that if there was any indication that he was having an affair, that would have been the Commonwealth's theory? Because they had all of his devices. They would have found something. their theory would have been that these were revenge killings. She found out he was cheating on her, and so therefore she took the children away from him, so he couldn't have them. It would have been a better theory than the one that they have, which in my opinion is so fakakta at this point. I don't even know what it is.
Yeah, there's not, no way. There's nothing. There's nothing.
No. If she's determined to not be criminally responsible, are they allowed to choose what mental facility they go to if they pay for it?
No.
Crystal wants to know. No. Because she's still in, like,
because I'd be like,
the system, right?
I would have pled already. Oh, I can go there? Yeah, all right. No.
Matea Trusty says, is the jury sequestered? Court TV said something about them staying at a Best Western. No, not sequestered. They're not in a hotel.
No, this Commonwealth is not going to pay for that.
No. I think somebody said that as a joke. I know what you're talking about because I saw that interview too. And it was a guy who was like on Court TV as a talking head who said that. And I just thought to myself, like, oh, here. Hold on.
One of my favorite court officers, by the way, is in that courtroom the whole trial.
Dave? Is it Dave?
No, it's a woman. I see her in Barnstable all the time. She's awesome.
What's her name? We got to shout her out.
I'm not.
Oh, we know everyone in the courtroom. We know the clerk. Her name is Dawn. We love Dawn. We love her outfits. Her pantsuits are like Tiffany blue and lavender. We love her. And we also love Dave. Dave is a court officer who's in there every single day. Shout out to Dave.
I don't know any of the other ones.
There's some really great support staff in all of the courthouses in Massachusetts, I find.
Yeah, I in a short that I did, I just talked about how when I was young and insane, I had a goal of trying a case in every courthouse in the Commonwealth. And now the goal is just to have a case in the rest of them. I think I've had a case in like 73% of the courthouses, and I just had my first one in Brockton the other day. So knocked another one off.
How many? It was Judge Sullivan that let Sean Sousa out, says Miss K. What? And it was in this exact county. Oh my God. Ermagerd. Also, did you see that Judge Sullivan just had a case overturned? There's a woman named LaTarsha Sanders who took the lives of her 2 children. And it was something of a, I don't know what, like a voodoo killing. And he did not allow in some of her psych records. That was just, the SJC just overturned it. She's getting a new trial. That happened. The SJC decision came down during the course of this trial, which made me think he might be a little skittish about not letting stuff in. So he's just going to let everything in. I can't believe Judge Sullivan let Sean Sousa out. Oh, man. Fall River is not in Plymouth County. That's in Bristol County. Did he used to sit in Bristol County?
I don't know.
I don't know. Oh, I'm sorry. I was asking the chat.
Oh.
All right. S. Hurtlocker. Question. There was a similar case in Ireland named Morley in 2020, January 24. 3 children, several similarities. Same day. 3 children, 2 boys, 1 girl, similar names. SSRI's pediatric nurse. There's no question in there, but thank you for telling us about that case. Charles from South Africa says that you look and sound like James Taylor.
I'll take that.
Thank you, Live in La Vida Loca.
Wish I saw.
Becoming a member and gifting 10 memberships. Go ahead. What? You wish you sung like James Taylor?
I wish I could sing like James Taylor.
Somebody else in the chat said that you look like Stephen King.
Great.
They're all over the place with their who you look like question.
Sure. Fire away.
Thank you, Live in La Vida Loca, for gifting 10 memberships. You're amazing. Rebecca says, stage 4 breast cancer, estrogen fed, not sure I could understand what hormones and medication can do to you. 3 young kids, probably memory issues, would affect you as a nurse and mom. Had to research her meds. Yeah, I didn't see anything wrong with her Googling all her medications. To me, that's something that everybody does.
Every one of my clients is a Google lawyer.
Yeah, it's a pain in the ass, right? Or I have a friend who has a friend who got this much money in their case, or...
Why aren't you doing this? Because I looked up this and it says this. And I said, let me see what you got. Oh, the case from New Jersey? Yeah. Go find a lawyer that's going to practice New Jersey law in the Commonwealth, sir.
And Rebecca, if you're speaking of yourself when you say stage 4 breast cancer, I send you all of the love and light and healing vibes. And we are thinking of you. Nico says manslaughter might make sense if you see her refusal for all help given to her as reckless, knowing she had thoughts of harming the kids.
That sounds like manslaughter on the psychiatric world.
Right. I think the act itself has to be reckless, not
Correct.
the refusal of the medications and her not, they tried to show she wasn't a compliant patient. They tried to show that she wasn't telling everybody everything about her thoughts. Oh, here, the camera's shaking. I think they're coming back. Here we go.
Your Honor, before the court, we have the matter of Commonwealth versus Lindsay Clancy. All parties are present, excluding the jury.
All right, counsel, it's my intent at this point to bring the jury in and then excuse them till Monday morning. Okay?
Yeah, I mean, they barely had enough time today to even watch that whole video, which I hope that they did. I would want to see it. I still want to see it. I want to know what Lindsay said. I want to know her demeanor. I want to see her body language. I want to evaluate her veracity.
All right, jurors enter. This court is now in session. Please be seated.
Your Honor, for the purpose of the record, present before the court are 12 deliberating jurors and 6 alternates in the matter of Commonwealth versus Lindsay Clancy. All other parties are present.
All right, well, good afternoon, everyone. What I'm going to do, it's been a long day for everybody, so I'm going to excuse everyone until Monday morning, 9 o'clock, where to resume deliberations. You know what I'm going to tell you now. All right, and then it applies to everybody here. You have to be vigilant to follow those instructions. Don't talk about this case. Don't talk about the deliberations. Don't listen to anything. Don't read anything. And just put this out of your mind as best you can. And we'll see everybody on Monday morning. Okay? Thank you.
Court, all right. Jurors,
See if they show the gallery. Father Bob hasn't been back, I noticed. I see Lindsay's parents. I don't know that Patrick or his parents have been back to court.
That's her family.
Yeah, those are her parents. And Dr. Zeisel has the white hair and white mustache. And that is Patrick Reddington's son, standing with his back to the wall. He's also a lawyer.
court's back in session. Please be seated.
Anything we need to address at this time? All right, so we'll be in recess on this matter till Monday morning at 9 o'clock. Thank you.
Court, all rise, please. Court stands in recess.
And that's it. Jerry's being sent home for the day. So how many, I guess they were at it today for, what time do they come in, 9? 7 hours? They can deliberate during lunch if they want to, right? They don't have to, but they can.
Right.
So, I mean, I've been predicting since jump that I think this is going to be a hung jury. I just don't see how 12 people are going to be able to agree on this. I feel like it's just watching the discourse and even my chat and what's going on out there on social media, that the people who think that she she killed her kids, she's evil, full stop. There's no excuse for that. She should just go to prison forever. And the people who have some, compassion or understanding of postpartum psychosis and the fact that we can use mental health as a, not an excuse, but as a defense. I don't think those two people could ever agree. What are your thoughts? What do you think they're going to do?
I can certainly understand what you just said. Reddington helped pick the jury. He's probably got twice the experience as those two prosecutors combined. He did things, everything he did was purposeful, knowing who was on that jury without alluding to the Bible or talking directly about the Bible. There's only been, there is, excuse me, there hasn't even been a question. They just asked to see things, right? That's not a question.
It's not a question, right?
So if they start asking for definitions of charges of counts of murder, manslaughter, and second degree,
Then they're getting close.
well, and then they're not coming back out. That is where I sense that a hung jury is happening. They come back and ask for the definition of reasonable doubt again. They're getting close. There's somebody who is not understanding what reasonable doubt is, because as the jury instruction says, it's often used but not understood.
Have you ever used it?
Used what?
Not criminally responsible as a defense?
Oh, no. No.
Because it's very, people don't understand how very rarely it's used.
And how difficult it is.
Right.
For both sides.
Right.
In the process. It's case, rebuttal, surrebuttal, and then rebuttal. It's the process is difficult too. So I'm guessing either hung jury or manslaughter at this point.
Yeah.
I wouldn't be surprised. I would not be surprised at a hung jury for the very reason that you're talking about. Manslaughter makes it more potentially more likely that they would be able to agree on something having to do with that rather than first or second degree.
Do you have a couple of minutes to watch the jury instructions with me?
I went for my bike ride this morning, so I'm in this because you're well rested. Obviously, I'm on here till midnight.
All right. Let me. Oh, I just had the stream pulled up, and I gotta just find it again. So give me 1 second. Because I want to hear the jury instruction on manslaughter.
Yes, I actually have it on my computer.
Oh, good. You want to just read it to us then, so we don't have to listen, or do you want to listen to the judge read it?
I kind of want to listen to the judge read it.
Yeah, me too, because maybe he took some stuff out. All right, where is this? This would have been day 23, which was yesterday. Hold on. I mean, no, today's, I don't know what day it is anymore. Yesterday was day...
Today's the 28th.
22. I think yesterday was day 22, and it was yesterday that it read that right. Let's see. 5. Okay. I'm gonna get to that part of the feed. Somebody said that they thought he put the quarters down because he was talking about their two-bit lawyering. They're two-bit lawyers, which would have been funny. So here, this question is, can you explain how the option of manslaughter is appropriate here? I saw that short yesterday. Well, let's play the jury instructions because we didn't get a chance to do that yesterday because we kept getting cut off. So let's listen to Judge Sully, as I have affectionately come to call him, read the jury instructions to the jury.
In our appellate courts.
Maybe it pertains to fewer than 3 of them, the manslaughter.
Oh, let's see.
The defendant is guilty. The law, I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless your guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous.
What do we mean by reasonable doubt? Commonwealth versus Webster.
Say again?
Nothing. I am experiencing again what he's experiencing right there. The trial is over and the instructions are being read, and he was scribbling.
I know.
He's fried. He's fried, and just give him the instructions.
The exhaustion has set in. And it's mind-numbing how many people and how many jurors don't understand the concept of reasonable doubt. For example, if you think she could have been in psychosis, that's reasonable doubt. If you think, oh, maybe she was in psychosis, I don't know, that's reasonable doubt. And I feel like he could have hammered down on that so much more in his closing, but, you know, it is what it is at this point.
The Commonwealth versus Webster is where Commonwealth still uses the definition of reasonable doubts from the 1800s, and it sounds like he's about to, maybe he's going to do it here. I find it to be pretty, it's a good instruction, my opinion.
All right, let me see. Tell me if you want me to stop it, and I'll stop it.
Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well,
here we go.
The term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. The charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you.
Is Massachusetts the only state that uses moral certainty as a standard?
I don't think so.
Because you don't hear
But I'm
that
not
often.
sure.
Yeah. Well, you're used to it because that's the only place you've practiced, right?
Correct.
Okay.
That every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk.
I tell jurors it means you're sure.
My function of the judge. My function as a
I'm sorry, I didn't hit the stop button. You say what now?
I frequently say to jurors, and I've been yelled at a couple of times by judges, but to me it means you're sure.
Reasonable, that beyond a reasonable doubt means you're sure. Okay, got it.
Judge in this case has been to see that the trial was conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider is evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law.
It's the first time
If
I've heard
jurors
that.
in each case
Yeah, he put his little spin on there. He's doing a little improv in between. I like him. I find him to be very
He's great.
affable, and I like the way he stands up when he addresses the juries. Do all judges do that? Because I don't think Judge Cannoni ever did that.
Only
Maybe
the
an
ones that
extra
have
day.
only the ones that have bad backs.
were to apply what they thought the law should be, and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are
I mean, he can say that all he wants, but you can't tell. I mean, nobody leaves their common sense at the door when they come in to serve on a jury, right? And if you're just totally turned off by the prosecutors and the way they tried this case, you know, some of them might just feel like they didn't like it. You know, you're not supposed to take that into consideration, but jurors do take that into consideration. It's just a fact, right?
Yes.
not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law, which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference, against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case.
Openings, closings, objections.
Is never evidence. Only the answers are evidence. So if a witness agrees with...
Yeah. Openings, closings, not evidence. Only what the witnesses say are evidence. That's what you said.
Objections, judges' rulings on objections. Stricken testimony.
Yeah, but you can't unhear that. You can't unhear that, mortal sin comment that was made twice, even if you're told to disregard it, right? It's
Correct.
out there.
Yep.
That's why I think that's reversible error if she gets convicted. Do you?
That, you know what? I just came up with my reason why he was putting those quarters down. Dirty pool. There we go.
Dirty pool. Good one.
A fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions and anything that I've said during the trial, not evidence. All right. So if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence.
No, the verdict's not coming in. The jury's been sent home for the day. There's a banner scrolling at the bottom. We are watching the judge's instructions to the jury because we've had a lot of questions about them. And also because of what happened with yesterday's stream, I didn't get to watch them with you yesterday, so we're watching them again.
Let's see if he uses...
They're coming back Monday, everybody. Go ahead.
Let's see if he uses the mailman analogy for circumstantial evidence.
All right, good. Yeah, that is in the jury instructions, right?
Yes. Well, there's 3 different things.
Oh, okay.
Mailman's one.
There's 2 types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when Circumstantial evidence is when no witness can testify directly about the fact that's sought to be proved, but you are presented with evidence of other facts, and then asked to draw reasonable inferences from them about the fact that's sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses.
He did not use it.
It's going to be your duty to decide all the disputed questions of fact. You are going to have to
Shout out to all the mail carriers who listen to the show while you're working, because there's quite a lot of them in the chat.
determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says, or only part of it, or none of it at all. If you do not believe a witness's testimony that something happened, of course, your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying, and whether the witness displays any bias in testifying, and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony.
Most important tool for a criminal defense lawyer.
Admitted into evidence.
That again?
In my opinion, in my experience, the most important tool for a criminal defense lawyer, or any trial lawyer really,
Is what?
but being able to effectively use prior inconsistent statements or subsequent inconsistent statements.
I forget what it was that the Commonwealth, the ADA, tried to like impeach her own witness about something that wasn't even very important. I forget what it was. Do you remember? It was so
kind of, yeah. It was. It seemed unnecessary. Yeah, it was. Who the heck was it?
And it'll come to me. It'll come to me.
Yeah, because they got a. Was it a mom? Was it?
I thought it was a family member.
Yeah.
You guys remember in the chat? Let us know. She whipped out like some grand jury testimony, and she's like, "Well, don't you remember you said this?" And it wasn't even something that was very like important or relevant about how much time it took. The constant pressure on the. I don't remember if that was it. I thought it was a family member, or Patrick, or somebody like that. I'll think it'll come to me. All right.
Solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by...
I thought it was Patrick. It's coming to me, and it was Patrick, but I don't remember exactly what it was. Now, if it was the medical examiner, that would be a little bit more material to me. I remember it was something that Patrick said, like to the police. Like, don't you remember you told the police this and not that?
I think it was Patrick, because he was testifying a little more lovingly than I think was expected on a certain area.
Yeah.
Maybe not lovingly, but not as.
I remember she did it with the medical examiner too, but that's not what I was thinking of. And yeah, the tying of the exercise bands. Don't you remember you said that it was like you tied them and it was like tying, or they were tied and
That's
that
it.
it was tied like a shoelace without tying it into a bow? But then she did that ridiculous in-court demonstration when Dr. Laposada was on Zoom, and she like wound the exercise band in the air and then threw it on the desk and it unwound as if she was making some like point. That was like her, you know, Matlock moment or something.
Isn't that what Reddington said, the if the glove doesn't fit moment?
Yes, yes, he brought some OJ into this case.
Showing that he or she previously rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence.
Oh, just so you know, that's Dave, the guy who's this court officer who's walking out of the courthouse right here.
Yep.
I mean, we're walking out of the courtroom, walking backstage. He's going off stage.
I'm
with
trying
their
to,
present testimony.
I don't think that's my
The one that, you
friend.
know, this is a blonde over here.
Yeah, I don't think that's her.
There's been another one who's been sitting over right next to Lindsay on most days. I know who you're talking about.
Yep.
The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness.
Yeah, the subtitles do not match this video, right? Sorry, I'm going to take them down. It's so weird. It's like the talking heads, the talking heads are on the captions. It's so weird.
Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence.
I think maybe it was Patrick's father. Like, don't you remember saying that she looked beautiful and she had a pretty dress on? It may have been. You may be right, Rudy.
To that effect. And I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses.
Let's see how it goes. So she also tried impeaching Patrick on an anniversary memory post by Lindsay, but it was 2021, not 2022. Yeah, it was something else too. I just don't remember.
Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, Witnesses may testify only to facts that are within their own personal knowledge. That is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right. Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify.
This has to be requested by the defendant.
This case is on the.
Say again, this is not an automatic in a criminal trial?
Defendant has to request it.
Wow.
Because it's like ringing a bell.
Yeah.
Except that it's pretty clear they didn't see her testify. So, and this is one of the best worded instructions that there is. I ask for it every time. Because it basically says, you can't, not only can you not consider it, you can't talk about it, you can't even think about it. So don't.
Right. You can't consider it at all.
Go ahead.
After I called I'm just telling this to the chat. I referred to one of the bowhead yesterday as Nellie Olson. And since so many people did not even know that there were two ADAs, you thought there was only one person. I now give permission, motion granted, to call them, to refer to them as the Olsen twins. How great is that? Okay.
Absolute right not to testify. Did not, all right. Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of the exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence.
Well, that answers the question. If they came out and they wanted access to the Ziploc bag full of the pill bottles and the knife, then I guess they're not in evidence.
That's what I figured.
And because they have all the evidence and exhibits back there with them. I just need to confirm what it is that they actually asked for, because it was held at sidebar. So anything that we hear is just rumor. I don't know. That was the only thing they came back with today.
Mark them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations.
Limiting instruction
the
on
images depicted are not pleasant.
Yeah.
Yeah, limiting instruction on the autopsy photos.
Yep.
The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts. All right.
Some people took that to mean that they're not allowed to bring their notes back into the deliberation room, but that's not what he said. Why would you not be able to bring your notes back with you? Why would you even take notes if you couldn't bring them back with you into the room, right?
Yeah, but I've seen that happen. I never understood it.
I think he's just saying don't rely on your memory more than your notes because your notes might not be accurate. Don't use them to convince another juror. But they can bring their notes back with them, is what I understand.
I believe he's letting them. And I think there was a question about the instructions being typed out for the jurors. It depends on the judge, but I believe this judge said that he gave them the instructions, the initial ones. I'm assuming they have them now, and frequently judges let them bring everything into the jury deliberation room because oftentimes the first question is, can you redefine whatever?
Right.
The less likely to have to do it if they have the definitions in there.
Exactly.
Right. Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear. All right. So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard. All right. We said
Google jurors.
Google. Yeah. I mean, they shouldn't even be able to bring their phones with them to deliberations, I think.
I think that's where you have to give them up. Shut them off and put them in a basket like you're at a party.
Right. And then like on lunch, maybe if you need to reach your kids or whatever.
Yeah.
So I just kind of want to make that real clear. Nobody is to use a phone to communicate.
It's the harshest I've heard him speak.
Talk to anybody.
Yeah, he's so jovial.
While you're deliberating, don't try and look up anything, things like that. All right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a four-person for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the four-person is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the four-person on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the four-person on your behalf, and then it's recorded in the case. All right? So those are the two roles of the four-person. So in this case, I'm going to appoint.
Is he not giving them the elements of the crimes at this point?
He gave them the elements in the beginning.
I mean, how does he not give them again at the end? I guess he's
That's
giving
why
them in writing?
I don't know. I was expecting them now too, but he also said he was giving them the jury instructions. So I don't know.
All right. Well, let's watch her pick the alternates.
Seat 18,
Bingo balls.
juror number 257.
They're not even. Watch this. It's like a cardboard box from Amazon. It's crazy.
It's the four-person of this jury. Okay.
It's the first time in Massachusetts. In New York, the four-person is always the juror in seat number one, always automatically. Every Massachusetts trial we've watched, it's always been seat number one also, but he picked a different seat. I think this was like seat number 13 or 14.
In this case, I'm going to appoint in seat 18, juror number 257 as the four-person of this jury.
Older woman, right?
Yes.
Fastidious note taker.
I think so, yeah.
He was eyeballing that. That's why.
Yeah.
Like a mom, grandma.
Now, members of the jury, if during the course of your deliberations, you should have a question about the law or about my instructions on the law, and by telling me this, I'm not suggesting you'll have one, but if you should do the following, all right? You should all first agree on the form of the question, have the four-person write it down on a piece of paper, and the four-person should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it. And then I'll either bring you back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room.
Seems like that's what he did this morning.
So now that process may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers.
No, it will cause a lag time.
Always.
Not may.
Always. Let's just see if she's going to.
Some lawyer is too far away, usually.
I was going to see if.
Gets sick or a family emergency.
Yeah, here's how she picks the alternate. See, I mean, if you look at it, it's like a cardboard box. Look, what's going on?
That's the first time I've seen that.
See?
Juror number 157 and seat number 11.
It's like she's pulling out like the 50-50 raffle at the fair. The fundraiser. And so that goes on. We had a great question here, though, because I wanted to know this, too. Do they, because we had some thoughts about the way they did this in one of Karen Reed's trials, but do they show all of the lawyers ahead of time, everything that's in there to make sure they've got all the jurors' numbers in there?
Nope.
And do they afterwards show the attorneys the actual things that were pulled out of there?
Not that I've ever seen. I'm sure that not that I've ever seen, but my experience is no.
And you've never asked to see them? Because I would be sus of all of this stuff.
I have not.
To know. Yeah. I mean,
I have not asked.
This is totally different than we've seen it in many. All right. I think that's enough for now. If you have the jury instruction of manslaughter in front of you, do you want to read it?
Let me see if I can get through.
Deborah says, RN case manager here. If guilty, the state will have to find a facility, corrections, prison, that is able to manage Lindsay's level of care. I know in Virginia, it's very difficult to find a facility that can. I don't know how many options there are in Massachusetts. If manslaughter, will she go to an institution? No, she goes to prison, right?
Right.
And the sentence
Well,
would be
she could go to the house of correction too.
right, but it's up to 20 years. But she's not going to go to a mental hospital, is what I think the question meant,
Right.
or mental institution.
Oh, there they are. Let's see. I have all the homicides. Homicide, self-defense, voluntary manslaughter. Can I share as if this was my show or no?
I think so. Yeah, I think there's a way for me to let you do that. Hang on.
Let's see. I have a present thingy here. Let's see what happens. Oh,
Okay.
oh my God.
It
And
worked?
I can. Oh, I don't want image file. Here we go. I'll get there. I will make you proud someday.
Yeah,
Attorney Little.
I'm always proud.
Share screen. Share screen. Window. And where did the jury instructions go? Yeah. Oh, there they are.
Sometimes you have to share the tab. Oh, no, it's window. It depends on how you opened it. If it's in your browser, you share the tab instead of the window.
Oh, there they are in the tab. Select the tab to share. Oh my.
Oh my God.
Can you see that?
Yep. Hang on.
I can't see me now. Oh, you know what? I have to lessen it because I have to put it to the side, right?
Hold on. I can do it. No, I have to do it on my end. I got it, though. I see it. There you go.
They begin at the top.
Do you want to read it? You want me to read it? I can't see that. That font is too small for me.
I can't.
Wait, but
Hang
we
on.
don't know if he
All right, I'm going to read it.
if he instructed any mitigating circumstances. I don't think he did.
So I'll just read the first paragraph. To prove the defendant guilty of, no, that's murder in the first, a mitigating circumstance, killing, manslaughter as a lesser included offense. To prove the defendant guilty of murder in the first degree or second degree, the Commonwealth is required to prove beyond a reasonable doubt that there were no mitigating circumstances that reduced the defendant's culpability. Yeah, so he didn't. No heat of passion.
No provocation. No sudden combat.
We had a little bit of that in mine. Excessive use of force. That is a little bit in mine. Absent a murder charge. Do you see that?
Yeah.
In this case, the defendant is charged with voluntary manslaughter to prove
But there is a murder charge, so that wouldn't apply.
Oh, that's right.
Yeah. I think he initially asked for involuntary, but then it was just a manslaughter. So I think maybe you don't need intent. It's just a reckless standard. You don't need the intent. I guess it's a mens rea thing. And so I don't know how it would really apply here at all, but it could be a compromise verdict if the jury can't agree on the murders. That's what I'm thinking.
Yep.
Like extreme atrocity and cruelty, but how could you not find that if you think she's guilty? Obviously, this extreme atrocity and cruelty to, do it with exercise bans. The amount of time that it would take to do it.
That's why there's something in my head that's saying that it may apply to fewer than all three. There's got to be something in the evidence that caused the judge to give that one.
I don't know. Do you think a bench trial did we talk about this earlier about the bench trial? Somebody asked, do you think it would have been better for a bench trial? As clearly there was enough doubt when proving any charges. They did not prove she even did it, according to this viewer, Sunflower Day.
No, I think jury was the way to go on this one. Because you have the master defense lawyer who probably, had a read on the prosecutors, and obviously at some point closer in time before the trial started, sort of recognized what their theory was and probably thought that a jury might say, what the hell are they talking about? You need, it's got to be unanimous.
Yeah. Unruly Teens and the Devil's Lettuce says, did I miss this testimony? How did Lindsay react when hearing of her actions? So much talk about asking for an attorney and meds. I feel her reaction to learning she killed her kids is vital info. Yeah, and it did come out in one of the last days of testimony that she didn't, when she woke up from her coma, which it wasn't even the same night. That witness said it was the same night that she was told what happened. But I don't think anybody ever testified about her reaction, chat. I don't know. Oh, and then Red's Devil's Lettuce says, Red said, leaving court today, the judge did allow the jurors to see the knife and the bottles. Okay. All right. So maybe they were in evidence.
Maybe.
And these are two questions that are similar. Julia says she needs to be observed 24/7, one-on-one due to her, suicidal ideations. Also, she needs care due to her disability. How does that work in jail if found guilty? And then somebody else asked a very similar question. It took 2 nurses to look after Lindsay during the trial. How can they humanely look after her if she goes to prison? I don't know what your system is like.
Yeah, that's extremely difficult. Depends on how long her sentence is. Depends on if she's sent to a state prison. There are certain prisons that are better equipped for that stuff. I don't know the specific details. I had one client who got smashed in the head with a bat, and had all kinds of issues, and he said better off in state prison than in the jail. Again, somebody who was familiar with the state prison, but they are required to care for her. So however they got to put it together, they would have to put it together. I'm hoping she's not going to a prison.
Yeah, we'll see. MF, thank you so much for your super chat and for saying that Rebecca of Something's Off podcast gave me huge props on her stream last night, saying that I'm wonderful and I'm so calm and beautiful. Oh, and she wants everyone to know. That's very sweet. Thank you so very much for telling me that. I appreciate you. This is a lot of people are asking this question because they're saying that Dr. Mack was fired from the Children's Hospital where he works. And so they want to know if the jury's going to be told that and if it's something that they could consider and
no
deciding how to weigh his testimony. I would say no. No?
Nope.
Yeah.
We don't know why he was fired.
Little Miss Motions, Melanie, how tall are you? Why do you want to know? I'm 5'8", a little shy of 5'8". I have a theory about why the jurors wanted to look at the knife. Oh, well, tell us.
After 2 hip replacements, I got an inch back of my height.
Oh my goodness. You did? Oh, you got an inch back.
Yep. I had lost it because they had ground down so far.
Oh, well, that's good. So how tall are you?
6'2".
Respectable. China Cat Son says, for Tom, I also have a 25-pound tuxedo cat. Does the vet yell at you because your cat's overweight? I don't like going to the vet due to that.
Doesn't yell at me because he's, I remember a long time ago, there was a Sports Illustrated cover of, I think he was a football player or a weightlifter or something, who was a very large man, less muscle than anything else, but he was described as the fittest fat man. And that's kind of how the vets talk about Liam, because they say he's so muscular under there, which is what I call him. I call him muscular. But, I got 3 cats and he's got asthma. George is old and has medication. So I have to put one on the refrigerator, one on the floor, and one hidden. And Liam finds where everybody else's food is when I'm asleep.
My tuxedo cat was 18 pounds, and I always made sure when I went to the vet to say, please don't fat shame her. Please don't fat shame her. She takes it very personally.
Yeah.
They said, you know, you have to get the cat to lose weight. I'm like, how am I going to get the cat to lose weight? I mean, I don't know. You can put her on a treadmill. What am I going to do? She likes to eat. I'd rather have a fat, happy cat than a really scraggly, skinny cat. That's just mean. That's just me. If a hung jury, what are the possible next steps? Thank you. A lot of people want to know if it's hung, will they try her again? And my vote is absolutely they will. But what do you think?
Me? Yeah.
Yeah.
Absolutely.
So
Come
what
back.
are the next steps? They would go ahead.
Start over. Pick a date. Get the transcripts. Get the record together. So now, speaking of prior inconsistent statements, and you probably have a defense lawyer who's sick to his stomach that he's got to deal with this again.
I think I heard he's retiring. I think is 70 the mandatory retirement age for judges?
Yes.
In Massachusetts? Okay. Foxy Wolf says, look at Crime in Progress, true crime post on Reason Behind the Court is perfect explanation. I don't know where am I going to look at that? Who is that? And where are they posting it? New way to look at it. Thanks for what you do. Thank you for saying that. Debbie says, Tom Hart's beat Soul Stain. When the judge just dismissed the jury for the weekend, Kevin Reddington looked very upset, not looking at the jury. Prosecutors were grinning and smiling at the jury. What do you make of this? It's making me nervous. I didn't notice that.
I make nothing of it.
Yeah, you never know.
I make of it a 75-year-old man who just did what he did, and prosecution who does not have an adverse verdict yet. That's what I read into that.
I think he also takes this case very personally. I think he he treats her like a daughter.
Yes.
East Coast Lands, although it would be against the oath they took, what do you think the odds are that the jurors have seen things on social media? How could you not? It's been highly publicized. I think they take their oath seriously. What do you think?
Yes, I do. Would I be shocked if somebody saw something? I mean, taking your oath seriously either means like you shut everything down and you shut yourself in a closet for the entire trial, or if you accidentally happen to see something or hear something, you shut it off or go the other way and report it to the judge, and then the judge will say, well, it's going to affect your ability to understand. So I think that somebody has probably accidentally seen a snippet of something and sort of run away. I agree. It's nearly impossible not to, or a family member who's that family member who you hope doesn't come to Thanksgiving, but does. And is like pumping, make him sit at the kids' table. That guy.
They did question all 18 of the jurors one day. I don't know what it was about, but nobody was excused. So something did happen. I'm not sure exactly what it was, but.
Well, there you go. There's your answer.
Right.
The answer is yes.
Elf wants to know, isn't manslaughter still a felony? Don't all felonies go to prison?
Yes and no. I was wondering what if Brian Camp was convicted. I would not have been shocked if he got probation based on the facts of that case. And the judge who was sitting.
Interesting.
So yes, it is a felony. You don't have to go to prison if you're convicted of most felonies. There are certain felonies. The case that I won the motion to suppress on, my 19-year-old client was looking at 12 years minimum mandatory in state prison.
Oh, wow.
So in that case, that one definitely goes to prison. Cannot do house of correction time, but manslaughter you can do house of correction time or get probation, or do 20 years in prison.
Up to 20 years.
Yes.
Fairy Raven is from Ireland. Her name is Emma. She says, I've loved and lost 6 rescue cats over 35 years, and all their ashes are coming with me when I go. Oh, Slancha. Cheryl said something about, hang on, I'll get to it. In Venmo. Did you know that Dr. Max stayed at the new owners of the Clancy house? I don't know that that's been confirmed. Like, I don't know where that came from. That's why Kevin Reddington pressed so hard on where he stayed. Interesting. So turns out that a former prosecutor or ADA from Plymouth County bought Patrick Clancy's house after the murders. He didn't want them to do the jury view. They did it anyway. Who wants to even live in a murder house? Did he get a really good deal? Like, that's just wild to me. These people that buy houses like that, I would just think that they were totally haunted, and I would never want to. I don't know that that's been confirmed, so I don't know where that rumor is coming from. Thank you, Crystal, so very much for your Venmo. Linda, a simple, inexpensive test to assess risk and mitigate against PPD is the omega-3 index test. Okay, great. Thank you for letting me know that. Jane, thank you for your Venmo. Alicia says, I had an abortion. How is what Lindsay did different from what I did? Rhetorical. Some states allow them up to 9 months. Massachusetts just amended the law, actually, and is allowing them up to birth, right? I didn't read the details on it. I didn't read the statute. I just saw the day that it was signed and it popped up.
Yeah, I wasn't sure. I saw it in passing. I didn't read about it, but that was the headline.
I think many people would disagree, Alicia, that it's the same thing. I don't know if you have an answer to that question or if it was rhetorical.
Yeah, my answer is I would rather talk to the uncle at the little kids table than talk about that kind of stuff at Thanksgiving.
Yeah. But it is important to point out that Matthew Farwell is facing federal murder charges for not only murdering Sandra Birchmore, but also her unborn baby. So that is a federal statute. Cheryl, thank you so much. And Haley said, shout out to my mom, Lisa, in Arizona for turning me onto your channel. We both love watching it. Well, you guys have really, really, really good taste. Thank you very much. And Miranda, every day she pops in to say, happy Friday, Lindsay is innocent. Enjoy the day off from the Lindsay trial. I enjoy every day. I'm like, Miranda, tell me why you think Lindsay is innocent. There are many people out there who do not think that the state has met their burden, that Lindsay and Clancy, in fact, did these crimes. What do you think about the Commonwealth having met their burden on anything? What are your thoughts on that?
I don't think they have.
Do you think they've met their burden on the murders themselves? Just that Lindsay did it? Really? That Lindsay did it, yeah.
Yes.
Okay. So do you think that they've met their burden to show that she was not suffering from a mental disease or defect that prevented her from knowing the
not beyond a reasonable doubt, no.
Same. I just, again, don't know if the jury's going to know what reasonable doubt is, and we never know what a jury's going to do. And Emma, thank you for your 3 matcha lattes. Tom, any final thoughts before we wrap it up?
I often find that the longer the jury is out, the more likely it is to be a conviction, because it's harder to convince 12 people beyond a reasonable doubt of even one count. They have 3 sets of counts plus the diminished capacity defense and the rebuttals and surrebuttals. So in this case, I don't know that it's not a rule, but it's just kind of experience. I think that they come back Tuesday morning. Okay, yeah. I said definitely into next week. GRB Chasers is the Daily Mail reported on the prosecutor that bought the house for $675K. Yeah, but I don't know where the confirmation is that one of the experts actually stayed with that guy at that house. I don't know. They'll come back after lunch, because everyone knows that juries like the free lunch.
Yes.
So they'll probably have their verdict by 11:30, and there will be a reading of the verdict at 2.
All right, you guys. Everyone have a great weekend. Stay cool, stay kind, stay classy. Above all, stay safe. Don't believe everything you read on the internet. I love you all so much for spending so much of your time with me. And I'm going to see you all real soon. Tom, just hang out backstage for a minute because I want to talk to you after this is over. And share the stream out, hype it when it's over. And peace out. See you guys later.
See you guys.
Bye. Oh, yeah, and go follow Tom. Where can they find you?
What is it called again? The Court Steps with Tom Kokonowski on YouTube, and Cape Cod Criminal Defense.lawyer and coco-law.com.
So if they need a criminal defense attorney in Massachusetts, anywhere in Massachusetts you go, right?
Yes.
I will also link his channel and his website below, so in case you or someone you know needs a criminal defense attorney,
Thank you.
You can call Tom. Love you guys. Thanks, mods, for everything. Hopefully it wasn't too rough out there today. Peace.